Hey guys, good evening, everybody. Hello. Um, um, good evening, guys. Heck of a beautiful evening tonight. Hope you guys had a really nice afternoon. Hope you had a rest nice of your day. Uh, it was really, 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 really nice tonight. The only thing it just need it's one of those nights where it's like just a hair of breeze, and it would have been like perfect. Um, yeah. Yeah, no, just want to say it's been a really nice day. I hope you guys enjoyed it. Like it's hard to say. It's like couldn't get that out of my mind. So, anyways, guys, welcome tonight. We are going to listen to the hearing Alec Baldwin had um, out in New Mexico, and this should be pretty good. So and if you guys remember the way this court does stuff, they do it like on Google, but it's like not the. It's such a weird uh, way they do it. So you're gonna see like with the Google Meet, and so you get to see it kind of that way go. So we're going to start that. Now, there are two places to watch it, and we are going to switch over to one of the people that have this hearing. First is going to be on Longcock. Sorry, we got to start there. Wish we didn't have to, but we are. And then we're going to switch over after a couple of minutes, but we got to start there just because it is available there. So, um, so that's going to be what we're doing. Zaman says react. Ah! There. Or you can say my reaction tonight, kind of like very chilled and nonchalant. Hmm. Although it does suck. I found out tomorrow, like Cleveland has a marathon and they're running it like tomorrow and Sunday, and I'm not really going to be able to go in and see my guy at the jail. My client at the jail I need to go see, and I'm like, well, that's not happening. So, yay. So I'm going to do that Monday morning. What happened? Did you get a huge court W? No, no, no. It's been a pretty good day. It's an awesome day today overall. Started out raining this morning. It's kind of like those mornings you wake up, but it's like a little rainy already. It's kind of nice, and we'll see what happens from there. Today was pretty good overall. 2.0 is never in chat now. Who scared her off? She's just busy. She's just very, very busy. Joe is doing a live reading tonight. He can't. It's Friday, so he can't do a live reading tonight. I mean, Joe's reading is the Talmud or whatever else Jewish people read on the night. So, not that. Not that chat. Nice try. April says, I'm enjoying how much you were streaming. It's very entertaining as well as educational. Thank you. Joe Boomer the time, certainly. It's probably tomorrow night. And Doug says, Joe shows on Saturday. Yep, I agree. That's how that's gonna be. That's how it's totally gonna be. So we're gonna get started though, and this is Alec Baldwin's challenge to the indictment. I know we covered the defense's claims, the prosecution's response, but now they're actually having a hearing on it. So let's get to it because there's a lot here, and you get to hear the like I said, I listened to about 30 to 45 minutes of it when I was driving back here this afternoon to do Karen Reed. Alec Baldwin's attorneys are phenomenal. I mean, let's be real. It doesn't take much to sound like you're flashier and dashier than Jason Bowles. So Well, Your Honor, here we are. We're going to talk about, like, doesn't take much. Doesn't take much to have a lot more competency than Jason Bowles. But Alec Baldwin's attorneys are pretty good. So here we go. And it is true, they are fancy New York lawyers. Fancy lawyers from New York. So here we go. Here we go, chat. We're gonna... Oh, there's my volume boost. All right, here we go, chat.
So, replies. So go ahead, let's start.
Thank you, Your Honor. I know the court has carefully read the papers, and we appreciate the long window the court gave today. I'm hoping it won't take that much time. How we'd like to proceed is break this up into two sections. I'll give you an overview of our view of the grand jury process, and then Mr. Nikas would take the second issue, which would be the waiver, the legal instructions, and the arguments and remedies there. So
this is Alec Baldwin's lead, Alex Spiro.
Just to start, and take a step back about.
Can I interrupt? So when you're arguing things, so there, as you know, there's two types of challenges, and I need you to hone in on which one or both you want the evidence you're arguing should be considered. So the sufficiency, quality, or sufficiency of the evidence, and then the second one is the structural challenges.
Yes, and Mr. Nikas is going to break that down in his sort of subsection.
Okay, very exactly good. Right. All right, thank you.
So just taking a step back, Your Honor, and I'm not going to obviously recite the history of the case here, but there's a couple of points that obviously the court, in our judgment, should think about and consider, which is the posture we found ourselves in before the grand jury was a case that had been dismissed and brought back. A court can consider, right, how strong a case is, whether it's at the fringes of criminal law or whether it's a case with 15 witnesses, DNA, and video, in sort of assessing these things. So we get brought back on a criminal case, and we were set for a preliminary hearing originally, and it was switched out of that posture into a grand jury, which is of course a prosecutor's right in New Mexico.
On a webcam, guy.
The purported reason was to sort of save the defense something or another, but frankly, we wanted our open court. We wanted the chance to press and cross-examine these witnesses. And the state took the proceeding and brought it into a private chamber. At that point, the notice went out, and it did not have the 48-hour language that, by Miss Morrissey's own statement to the judge, she had never seen a notice without that. And the identical notice served on the co-defendant on the same case didn't have this absence, right? Sort of surprising. Sort of looking at it, you're saying, what is this? And then further to that, we raise the issue, and there's a fight, a litigation, and the state lost that issue. Then there is the idea of this one-sided voir dire, which seemed a bit unusual. Again, we raised it, they fought it, they litigated, they lost. And again, these things just seem strange to be dug in on, right? And your mind kind of goes back. At least mine did, to comments that the judge made. Judge Ellington said, it's the strangest thing. In 30 years, he had never seen the media know when the grand jury was going to convene on a case before the target letter even went to the defendant. Strange. And I start remembering, these comments from the prosecutor about humbling Mr. Baldwin. This is a homicide case.
Now, I will say in response to that, homie, you're in New York City, big time fancy New York City lawyer. You're telling me you've never, this judge out in, shit kicking New Mexico probably hasn't heard it. But in New York City, we haven't ever heard of that. In Washington, D.C., we hear about never hearing about things getting convened, things getting done. I mean, it does happen. It's a hot, and what I think he probably should have included though is we do hear these things, but it's when it's a highly politicized and it's a questionable case, and it's being brought to cause problems, not necessarily bring justice. And he's kind of about to get to that, but I think he probably could have answered that a different way. Yeah, somebody said yes. This is over 2 hours. Yeah, it's actually it's very in depth. You guys are gonna like it. So.
No, when the grand jury was going to convene on a case before the target letter even went to the defendant. Strange. And I start remembering, these comments from the prosecutor about humbling Mr. Baldwin. I mean, this is a homicide case to humble another human being. And you start thinking, well, what's really going on here? And so ultimately what the judge ordered was that these witnesses, the evidence, be made available to the grand jury. He was not going to deal with logistics. This was the prosecutor's duty, their ethical and prosecutorial duty, to be fair, impartial, to be a guide and a help, not to be an advocate in that moment, to just be the eyes and the ears of the court and of justice. And so, I can tell the court personally, I was concerned, and we sent a letter the day before the proceeding to say, please, we get it. It's a high pressure case. We get it. Everybody, you want the indictment. We get it. There's all these things we've brought to the court's attention. The court ruled in our favor. The grand jury is going to be ending soon. Please, we're practically begging the prosecutor. Don't run through the stop sign. Don't be reckless. Don't lose your way. You have to have the witnesses and the evidence there, and the grand jury needs to know that it's there. It's a real process. This isn't rubber stamps. So, concerned about that the case was just going to be raised closed, we sent that letter. And I think that's very important, Your Honor. And I think the court should consider that. And from my position, the fix was in. There were no witnesses. There were no witnesses there to testify. There was no evidence binder of the defense exhibits. There was no evidence binder. So even if somebody had wanted to speak to somebody, there was no time, there was no ability. And that is so important, because the prosecutor never intended for that. You see? Just like prosecutors argue in summation. The truth is so compelling. They never intended for the grand jury to ask for witnesses. They never wanted the grand jury to ask for exhibits. And so not by deed, not by word, not by spirit, they did not comply with the court's order or the law. And surprise, the grand jury didn't ask for any of it, right? That's what the prosecutor is going to say. But of course, they were led nowhere. They were led to the closed door of the grand jury room with not sufficient information and explanation. And I'll tell the court, and the court's reviewed many grand jury minutes, and I remember many times when I was a prosecutor, but there's a way to do this that's fair. There's a way to say, this is a murder case. I'm just going to give the court an example. There's an alibi witness. This is very, very serious stuff. The defendant says that he was at the movies with his mom at the time. He could be completely innocent. There's a movie ticket right here. I'm going to leave it right here on the table. You all should think about looking at it. The defense would like you to look at it. The mom is in the hallway. Okay, we want justice here. You should consider these things. You don't have to do it, but I'm going to leave the movie ticket here and the mom in the hallway. And by all means, we want to get to the right result here. That's not what happened in this case. And so, and another thing is, again, our letter, the terms ending the next day, that you're going to have to, it's like, listen, understand, we're going to give you plenty of warning so that you can tell your job, so that you can have extra time. If you need more time, that's easy. We will accommodate these people who are waiting here. But there were no people. There were no exhibits because the state was never going to comply. So when we got the transcripts, of course, and we looked deeper at this, the witnesses were diverted, right? It's a very important thing that Ms. Morrissey was preparing for the Gutierrez-Reed trial at the time. She knew exactly what was going on.
I think that was a very good example he used about how the evidence was actually presented in a way that makes sense. I think it's very fair. Ag, he was trying to paint an example. It's not necessarily an alibi, but if it was an alibi that had been presented, that the state didn't do a pretty good job of it. So that's kind of what they're arguing here. And I don't think that was a bad way to go about describing it and explaining it. Song and Dance Lawyering 101. No, I mean, I think he is trying to do a very good job at that. Yes, part of your job as an attorney, especially he's out of town, he's not from there. Yes, he's going to be very deferential, very, very smooth. What's his name? Alex Spiro down here at the bottom. You guys can see their names at the bottom of whoever's talking. Now, it is funny because you'll hear all the attorneys on Alec Baldwin's side. And, Judge, we know you read everything fully and you give everything the proper consideration it's due. That's them just sucking her off. But you'll see that a lot more and more and more. So, Yes, rich people can afford really good lawyers. Alex Spiro is a very good lawyer.
She knew exactly how to divert the witnesses away from information that helped Mr. Baldwin. She diverted them. And the legal instructions, the filing that was made when the issue of the legal instructions was before the prior judge, the state says in there, it's just a little piece in the papers, but it says, we'll insert the language we intend to use. That's what they say in the papers. And they don't tell the judge, I'm going to insert this language that they ended up giving. They don't tell the judge that. And they could have called that judge back at any point and said, we have a question. Just because of all of the concerns in this case.
And guys, somebody wanted to bring this up real quick. How good is he? Well, I mean, we can look him up. Quinn Emanuel and Urquhart Sullivan, Alex Spiro. God, there's an old picture of him, but this guy has experience as an attorney. He works at a big firm. But he's in the New York office and he co-chairs the investigations, government enforcement, and white-collar defense part. Yeah, he went to Harvard, whatever. But he worked in the Manhattan DA's office and he indicted and convicted a couple of murders for a serial killer. For 2 murders in the 1970s. He also convicted another serial killer. And he also worked with the Conviction Integrity Unit, which are a big enough prosecutor's office has a prosecuting team that will review cases that, not only on their own, but if people bring their attention to them, they'll review the case and determine whether or not there truly was a rightful conviction. Now, yes, a lot of times that's the cops investigating themselves, but yeah, this guy was no fucking slouch. He's not a slouch. He's not just, this isn't fucking Harvey Specter. This is Harvey Specter. He kind of is like Harvey Specter in a way. Dude does a lot of practice. So, just telling you. So just something to think about. These aren't just, big shot attorneys who come in and just fuck around. These guys have made their bones generally.
Because we want to do the right thing. Is it okay if we insert different words? They don't do that.
Yeah,
they shut the door to the grand jury room. They got their indictment, and that's why we need this court to step in and check this abuse of power.
Yeah, this guy.
It's just that simple. I'm going to end and turn it over to Mr. Nikas in a minute on these specific issues. But again, I will sort of end where I began. That this is a case involving an accident at the outskirts. Very outskirts of criminal law as we know it, and I don't think there could be much debate about that. There was no check in that grand jury room. The prosecutor was alone to do as they wished, despite every warning and every judicial order otherwise. And, even in front of the court perhaps can see what I believe to be going on here, which is, and Mr. Nikas is going to address this waiver issue, that this response comes in from the state and has no case law in it. It's like a breathless, go get him kind of a response, and that's fine. But you start thinking, are we not losing our way here? Is the high pressure case not starting to sort of take control over good judgment and everything else? And I just think the court can have no comfort in this indictment, can have no comfort in the way it was procured, cannot possibly believe it was fair and impartial. It should be dismissed. It should be dismissed for Mr. Baldwin and for any other person that comes before a grand jury and falls the victim of an overzealous prosecutor. And that's what we would ask you to do. So I'm now going to turn it over to Mr. Nikas, if there are no direct questions for me to address the specific arguments regarding waiver, the legal instructions, and the legal remedies we sought.
No, I don't have any questions at this time.
Thank you, Your Honor.
Good morning, Your Honor. It's Nick Nicholas. I'm getting some feedback. Okay, I think it's a little better. Good morning, Your Honor. So I'm going to address 3 issues in a little bit more detail, and I'll try to keep it brief because we know Your Honor reads all the papers very carefully. So what I'd like to do is highlight a few key components of 3 issues in the case. The first is waiver. The second is the ground for dismissal that the prosecutors engaged in bad faith, and therefore the court should review the sufficiency of the indictment and evidence that supported it. And the third is the structural problems with the grand jury process in that it was conducted in violation of the law, and therefore no prejudice is required in order to dismiss. So I'll break it down into those three categories that we believe justify dismissal independently, each of them, of the indictment. The first, Your Honor, the state has waived its challenges to the motion to dismiss we filed. The state did not cite a single case in its opposition brief. It did not cite a single legal authority in its opposition brief. It did not distinguish any of our legal authorities. And it didn't.
Here we go. Now they start. And this guy does a lot of the research here. Now, there's a better quality version of this, and we're switching over to it. But the thing was, they missed like the first 10 minutes. So we're going to go over to it real quick, guys. I'm going to switch this over. This one's a little better quality. I think this one's a little better here. Okay. So we're going to rewind them just for a second. But here we go.
Motion to dismiss we filed. The state did not cite a single case in its opposition brief. It did not cite a single legal authority in its opposition brief. It did not distinguish any of our legal authorities. And it didn't challenge the majority of our factual statements either. And even when it did purport to challenge the basis for our factual statements, it mischaracterized our position and argued against something we had not, in fact, even asserted. For example, the state argues that Mr. Baldwin asserted the grand jury process was too short, and therefore that is one ground for our dismissal. As you just heard Mr. Spiro explain, our argument was not that the process was too short. It was that if the state was going to conduct the grand jury process consistent with the law, present the evidence that we believe was required to be presented, instruct the grand jury properly as to its roles and responsibilities, then a day and a half would not be enough time to do that. And so that was not a basis for dismissal. That was one of many, many facts that, as we laid out in our brief, points toward the mindset, the motivation of the state in conducting this prosecution, which was directly relevant to bad faith, where the courts have defined bad faith as dishonesty in purpose, belief, or motivation. And so even where we made arguments about things that were mischaracterized and responded to in a different way, when the state actually did respond. And so ultimately, the state waived the challenge, and we cited a number of cases to demonstrate that. For example, we cited the Delta Automatic Systems case. That was a waiver case. Now, short summary, Your Honor, just so you can see how on point our cases are versus what the state cited in its supplemental brief. Delta Automatic Systems, plaintiffs filed a brief. They argued their claim was not time barred. It was in the limitations period. The defendant explains, well, no, your case is time barred because actually the limitations period started earlier. Plaintiff doesn't respond to that. What does the court do? The court says, if you don't respond in opposition to an argument, then you've waived it. Dismisses the plaintiff's claim on the merits. There was no discussion of wanting to hear the case on the merits, no discussion of liberally allowing parties to ignore responses. Period, full stop, dismiss the case on the merits. Same thing happened with respect to an argument in State versus Vaughn. The defendant argued that the court violated his due process rights because he was subject to prosecution for refusing a breathalyzer test, when in fact the first breathalyzer test he took, he agreed to take. He said, you can't prosecute me for refusal when I gave one. Doesn't cite a legal authority to support that argument. Factually, it was true. Doesn't support one. What does the court say? You haven't cited a legal authority. We will not consider an argument that lacks citation to any legal authority. And when you do that, we assume no such authority exists. Period, full stop, rejects the argument. No discussion of liberally granting opportunities, etc. We cited the State versus Tafoya case. Same exact thing. Court explains, you, defendant, argued the jury instructions were insufficient, but you didn't cite any legal authority for that. Argument rejected. You don't cite legal authority. You don't oppose legal authority that's cited to you. You've waived it. And what does the state say? The state does not distinguish our cases.
It doesn't challenge those principles. Instead, if Your Honor even considers the state's supplemental reply, which we don't think you should because the waiver cases do not allow that, but even if you did, Your Honor, and you looked at the cases the state cites, none of those cases are about waiver. They're about default judgments, which we know is a very different scenario from waiver. For example, in the Gangler versus Phelps case that the state cites, the plaintiff sued two defendants. The parties agreed that the defendant's time to answer would be extended. When they entered the order, however, it only applied to one of the defendants. It was an accident. One of the defendants, therefore, didn't respond on time. The plaintiff got a default judgment. What do we think happened? Of course, the court said, we vacate default judgments liberally. And everyone thought this was supposed to apply to both. And so we're not going to hold you responsible for not responding on time.
The state got caught.
Springer versus Herrera, same exact thing. Default judgment entered, and the court says we liberally vacate default judgments. Nothing about waiver. SunWest Bank versus Rodriguez, another case the court cites, or the state cites to the court. This is an interesting one, Your Honor. There, for a couple of reasons. There, the plaintiff sued two defendants, a husband and wife, who had been separated because they defaulted on a loan. The wife or the ex-wife comes into the court after a default judgment was entered and says, I didn't know this wouldn't be handled. My ex-husband has all the information about this. I thought he was going to answer the complaint. And therefore, this is excusable neglect.
And this is what you do, guys. When you're trying to show why your cases are on point, you have to make these arguments. Your Honor, this is about X, Y, and Z. You know what? Yes, the overall opinion is correct, but the underlying facts were so different. Or, Your Honor, this is kind of, it sounds good, but when you really drill down to what happened, it's a completely different situation. This is actually this is oral advocacy.
Court says, fine. We think that is excusable neglect, but ultimately we don't find your defense on the merits persuasive. And therefore, we're keeping the default judgment intact. And why is this interesting, Your Honor? Because when you look at these default judgment cases, even though they don't apply here, even though the waiver cases are the controlling cases,
went to Harvard.
And we ask ourselves, even if we applied that standard, excusable neglect,
yes, it's a
would the state be able to meet it if that were the standard? Is the state's knowing and intentional failure to respond to any of our legal arguments, any of our cases, its failure to cite any cases of its own, excusable neglect? How about the state's failure to address any of our factual statements? Is that excusable neglect? No, it's not. This is not a case where the state failed to answer at all and said, oops, we missed a deadline by accident. Can we please file our brief now? Where in those circumstances, the court would look at law office failure and technical issues. That's not this case. This is a case where the state did respond, and they responded on time. And they made the response they made.
Guys, that's on their end. That's not mine. I think it's funny, though. This is Google Meet. This is whoever's recording all of this, that's coming through there. That's not me.
Deliberately, knowingly, with a calculated strategy to disparage Mr. Baldwin, to disparage me personally, rather than deal with this case on the merits, knowing full well the risks of taking that approach. This would not be excusable neglect, even if we did have to prove it, which we don't. And the state also cites this People versus Davenport case. That was a Colorado case about civil forfeiture, where the defendant didn't show up in response to a civil forfeiture claim, got a default judgment, and said against him and said, but that should be vacated. And when asked why, he said, because the statute says I can either file a response or appear in person. I filed a response. The court says, yeah, that's right. You did. You complied with the statute by filing the response. You forgot to pay the fee, but you can do that later under Colorado law. Therefore, the default judgment shouldn't have been entered in the first place. Those are the state's cases, Your Honor. None of them on point at all. The only one that has some language that, even if it were relevant, it's not, would actually support the entry of dismissal because of the state's waiver. And so the state waived these challenges. It was the state's decision to present its opposition as it did. the state's decision not to cite a legal case, the state's decision to do all of these things. And the state said, well, that wouldn't be fair. It wouldn't be fair. It wouldn't be fair to give them this opportunity, to have them take the approach they wanted, and then give them a redo. Let's talk about fairness for just a moment, Your Honor. Let's talk about what the courts say about fairness in the context of a grand jury proceeding. Herrera said we need to protect the target's fundamental fairness. Strict adherence to the rules is required. Willoughby said that prosecutors must conduct themselves, as Mr. Spiro said, in a fair and impartial manner. Willoughby said that it's the target's right to a fair and lawful process that should be rigorously protected. That's what fairness is about in these circumstances. It's fairness to the target. And the only unfair outcome here on waiver would be not to apply waiver cases and not to dismiss this indictment on the basis of those controlling cases when the state brought this circumstance on itself by choosing the response it made. That's ground number one, Your Honor, on which we believe the court should dismiss the indictment. Ground number 2 and 3, as I mentioned, bad faith and judicial review of the evidence, and then the structural defects in the process. I'm going to start with the structural defects in the process, the violation of the grand jury process. Under New Mexico law, that is a basis for dismissal without proving prejudice. Once again, the state doesn't cite any cases about this ground for dismissal. In the state's supplemental reply, they say we've misrepresented the fact that bad faith is not required. It's very clear, Your Honor, we put it in our brief that bad faith is required on the third ground I'll talk about, but it's not required on this second ground. The courts have made that clear in New Mexico. Herrera said, for example, when we're talking about a violation of the grand jury process, a different standard applies to the target's claim, different standard from bad faith. It's quoting directly from the Herrera case. And the reason is that the grand jury process is one where the prosecutor has the control. There's no direct supervision of the judge, as Herrera noted. The prosecutor has the control of the room, the control of the witnesses, and ultimately has to rigorously follow the grand jury process to ensure that the grand jury has all the evidence before it so it can comply with its obligation to receive and evaluate all of the exculpatory evidence, all of the evidence that may make an indictment less justified. And so in the Herrera case, I want to start there, Your Honor, because in the Herrera case, there were 2 grounds for dismissal, independent. One was that the prosecutor asked the witness a question and the prosecutor didn't let that witness answer it. And the court said, ultimately, if the prosecutor had questions about whether the grand jury should hear that information, should have its questions answered by that witness, then the prosecutor should have gone to the judge. And the second was, and we see a lot of that here, Your Honor, as we've explained in our briefs. The second is that the prosecutor read proper UJI instructions to the grand jury, but then commented on one of them in a way that was consistent with the instruction, but sort of expounded upon it a bit. And the court said, no, we have to comply rigorously. We have to read those instructions exactly as they are, word for word. We cannot manipulate, we cannot change, we cannot modify. It is critical that the instructions are exactly what they need to be. And they weren't, and that failure also provided a separate ground for dismissal. And so let's start here, Your Honor, with the 3 reasons we give on this ground, independent again, for dismissing the indictment on the basis that it violated the grand jury process. The first is that the jury instruction was inaccurate. The first element of the jury instruction that the state read was that probable cause exists if the grand jury finds that the target discharged a firearm during the production of the movie without first verifying the firearm contained no live ammunition and while the firearm was pointed in the direction of another. The state then had a witness testify that Baldwin had an obligation to verify the firearm contained no live ammunition. There are two pieces of this, Your Honor. The most troubling to us, the instruction is not correct. Judge Ellington heard argument on what this instruction should say, and we put our position forward, said it should reference Baldwin's subjective knowledge, which we do think is the law in New Mexico. And the state said, this is not about whether Mr. Baldwin should have verified whether the firearm contained live ammunition. There are other grounds completely distinct from that serve as the basis for this indictment. And Judge Ellington accepted that argument, that representation, that that's not what this case was going to be about. Shocked we were when we see the grand jury instruction inserting this exact language.
So guys, is that your dogs barking at the lawyers? No, that's the dogs. That's Laney having a bit of an issue there. So there better be a public trial soon. I hope Sean's going to cover it. Yeah, Alec Baldwin's set for trial in July. Now, I mean, seriously, you guys can make fun of him, but they are bringing up very good points. They're addressing the issues here that Alec Baldwin's claim is that when the prosecutor presented this to the grand jury and re-indicted him, Alec Baldwin had the right to demand, and 10K, you're asking about this, they had the right to demand that exculpatory evidence be presented to the grand jury and that it wasn't properly presented. And they're arguing because the grand jury proceeding wasn't done correctly, it's a motion to dismiss. And because it's a motion to dismiss, and now it's the second dismissal, it's now with prejudice and it's done. So that's what they're challenging. They're challenging how this was presented to the grand jury because under New Mexico law, it's one of the 5 states that allow for it. There's 5 where you are allowed as the defendant to demand certain evidence be presented if you could show it's exculpatory in nature. And that it has to be presented, not just, oh yeah, here's a folder of shit on the table. No. The prosecutor has to say, this is also to be presented before you to understand and take a look at. Please examine these as well. Take these in for your consideration. If there's a witness, you have to give that, like you can give that witness and they say, here are the questions we want you to ask. Because remember, you don't get to be there as a defendant, but you can tell them what you want to ask. And the prosecutor's going to say, did this happen? Did that happen? Yada, 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 yada. And they have to answer it. So that's where we are with this. They're actually doing a very good job. I mean, so the grand jury guys, and this is where every state's a little different. But yeah, Sweet Tooth, actually, it's probably easier for me to explain that way and start off there. Thank you for helping with that. So the grand jury, you do have the right to testify, but it's not always a good idea. But you don't get to sit there and make sure this happens. This all happens outside your purview. And testifying for the grand jury would never be a good idea because Alec Baldwin doesn't need to. But there's enough exculpatory material, they believe. So what does the grand jury do? Well, the grand jury is a closed setting of one-sided presentation. And you generally have a room full of people and they're all hanging out. And I've done grand juries before. And you usually come into a room, there's like, depending on the state, like in Ohio, it's 9. There's 9 people sitting around. They're just hanging about. After they get picked. And you bring in, you come in, you say, hey, good morning, everybody. Today we're going to talk about a proposed case. And this is the state of Ohio versus Alec Baldwin. The charges are that it's alleged that on October, it was the 19th of 2022, that Alec Baldwin did commit the crime of involuntary manslaughter by doing yada, 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 against a piece of dignity in the state of Ohio. And obviously they'd say New Mexico. And then the other thing he's being charged with, ladies and gentlemen, is involuntary manslaughter under this section. They'd read it out and they'd say, so that's what we're here for you to consider. Now, our first witness is Detective so-and-so, and they'll bring in Detective Ducklips. And she'll come in and she'll talk about the case. They might bring in Joel Souza. You, Mr. Souza, you were there. Yes. What happened to you? And they'll go through testimony. Were you shot? Yeah. What happened? Like, and they'll go through all of it. You can ask leading questions. There's not really any rules. The couple of constitutional things, though, like your right to silence under the Fifth Amendment, still protected. But overall, they're going to bring up what happened. And then after it's over, you say, ladies and gentlemen, we presented you with all the evidence here. Now, New Mexico, though, that's when the defense evidence has to be presented. And here's evidence, additional evidence for you to consider. And they ask all of that. But then you think, so here's everything. Once again, we are asking you to determine whether or not he has committed these crimes. But also the grand juries can also indict you for other crimes if they think you committed another crime. You know, if they thought Alec Baldwin had committed felony theft or embezzlement, they could indict for that. But what will happen is everybody goes outside and you leave the grand jury to deliberate. And usually you just walk outside, close the door, and everybody hangs out. Like the court reporter leaves. The court reporter's been sitting there the whole time transcribing it. The witnesses, everybody comes out of the room, and it's them for a while. And every once in a while, they come back and say, hey, we got questions about this, that, or the other. Then you say, okay, well, what's a question? And you're like, can we ask this? We have some questions for a witness. And you bring that witness in. It's like, okay, well, I have questions about this. I have questions about that. Okay, cool. And that you ask that witness questions, they answer them or whatever. Sometimes they ask questions like, we can't answer that for you. That's not a question I can answer. Generally, though, they're asking like legally permissible questions. And you bring that witness in and they'll, okay, yeah, what's your question? And they'll answer. And the witness will answer. And you come and like, okay, well, does that help you guys? Yep. You go back outside and wait. And they say, we've made a decision. And you come in and you're like, what is it? And they're like, oh, we're going to indict or it's a no bill. And you move on. Okay, cool. Thank you. You give everybody maybe a minute or two. Like if they need to get a drink or they want to get a coffee or whatever in that room, you're like, all right, guys, we're going to move on to the next case. And it's State of New Mexico versus Hannah Reed. Or they move on to the State of New Mexico versus Luke Pearson. Luke says, which will come up later because that's pertinent to the Herrera case. Yes, there's a lot there. Anonymous says, just joined. What's the news? Was there a verdict? Also, say hello to the pup for me. Thank you. Hi, Clyde. So, is this good or bad for the defense? Right now, I mean, the defense is making a bunch of arguments that we weren't properly indicted. We didn't get our shot in court, so it's not fair. Therefore, dismiss the case. But remember, this is the defense. They get to go first. They're going to, obviously they're going to sit here and beat the drum. We've got the sexiest stuff out there. I don't know the New Mexico case law. Both sides here do. So we'll hear what Carrie Morrissey does in a second. And she's going to get to go too. She'll get to respond, but let's listen to this guy make his responses. And I hope that's answering your questions too. He committed not saying free Palestine. Yeah. So Sweet Tooth, yes, typically, so like 45 states, it's just the defense, it's just the prosecution. In New Mexico, you have the right to testify, you have the right to have evidence presented, but you don't present it. So, for example, let's say you were in New Mexico and you were getting indicted and you hired me, we wouldn't get to show up in there and say, ladies and gentlemen, here comes the defense attorney with evidence. Nope. If we provided enough proof and satisfied all the requirements, the judge would make a ruling in writing and he would demand Carrie Morrissey and he'd say, listen, you're going to present X, Y, and Z to the grand jury as part of your presentation. You're going to make no illusions that it's anything other than just another witness. And here's evidence you're going to consider. And here's the evidence. Here are the questions you're going to ask. And you must comply. And that's what's told to Carrie Morrissey. So it's a little different in a couple of states. Most states, you don't get any opportunity to do this. A handful of states will. And every once in a while, as a defendant, you may be subpoenaed to testify before a grand jury in which they're looking to indict you, but that's very, 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 very rare. And let's say that does happen, you do have the right to have counsel present for that because you always have a 5th and 6th Amendment right. So I hope that answers questions. Why is it called a true bill or no bill? That's just an old thing there. You know, it's a bill of indictment. Like a bill of attainder, a bill of indictment. You know, it's you man I call Clyde. Yeah. Yes, the case of Ohio versus Clyde T Dog. Yes. So 10K, you're saying you talk about the DA only having 2 bites at an apple. Typically, yes. You the first time you indict and charge somebody and you dismiss it, you can dismiss it without prejudice, generally before you've reached the jeopardy stage, meaning a jury has been seated. There are times where mistrials might happen that you are still, even after that, jeopardy didn't attach, but generally it's up to the point of a jury seating. You could dismiss and then refile as long as you're in the statute of limitations. It's that second time, for the most part, and the way criminal law works in America, that second time is it. You don't get another shot. There might be exceptions, but the general rule is you get 2 shots. And if you miss on the second one or you whiff on the second one or things fall apart, oh well. That's what happens. So the second time it's a dismissal with prejudice. So Luke, you're mentioning the yeah, he's the cop down in Columbus. He killed the hooker or shot the hooker, right? Yeah, that guy had a whole set of issues there. That wasn't good for him. That guy was like, oof. So yeah, some people do testify, but it's a very, 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 very rare thing. Very rare. He's saying a lot of words, but he's absolutely saying nothing at all. Kind of, but he's actually saying a lot. He's saying a lot. I think so. Ten K View says that's a good process. I think it's a phenomenal idea, and it'd be nice if we could do that. No one wants to talk about his hideous desk. Here, look, here's the point. This desk is just proof that money does not buy taste. And I mean, look at this stuff here in the background, like these book things. That's just like table dressing or window, just like decoration. But like, where did they go to get this? Where it's like the book is New York. It's like they went to like Crate and Barrel, and his wife was like, "Oh my god, that'll be so great." It's like, you guys live in New York. It's like it's just so cringe, so cringe. But also, it just looks like this is a guy who moved into his house and it's not fully sorted out yet. I don't know. Whatever. No big deal. It's just, yeah, this whole thing is just, yeah, money does not buy taste. That's like a Fate Team's background, though. No, it's real. It's real. You can see the trees move a little bit. Yes, the bald man is providing the arguments. This is the brains, and Alex Spiro is the flash and dash. It's kind of like Harvey Specter and Lewis Litt. Specter gets the talk. Specter, does the foreplay, and Lewis comes in and does all the hard work. I hate to use suits as an argument for things because so much of it's not true. But these guys are good. And also, yes, he sleeps in that suit and tie. Well, that guy's got a very nice suit. Nice suit. If only I could have a suit that nice. You have to lose a little weight, though. So, here we go. He thought it's Alejandro Mayorkas. Jeez. Alan says you can also have money and not care, like me. Yes, that too. But, I mean, this is just tacky and gaudy. Oh, my God. It's awful looking. Yes, and Richard says the N-word and Sheriff Fossey does the grilling. All right, guys, we need to get going. We need to catch back up here. I'll make better efforts to stop. I'm sorry, because I'm just listening and taking it all in. And this is not the part I got to hear. I got to hear a little bit later in it. So I'll make a better effort to stop every couple minutes and we'll talk.
Language that the state had just argued was not going to be the basis for its case. Again, the grand jury judge was there for guidance. If the prosecutor had concerns about whether this language could be added in, that's what the judge was there for. That's what Herrera said the prosecutor should have done when deciding to cut off the witness. So that's troubling, Your Honor. What's even more troubling to us is that the state called Brian Carpenter to testify in the grand jury. And Brian Carpenter testified that it was Mr. Baldwin's responsibility to check the firearm. It was Mr. Baldwin's responsibility to verify the ammunition, and the gun was not live ammunition. It was instead a dummy or a blank. And that was definitive. They also had Detective Hancock say that the actor had to do the safety checks. 2 weeks later, Your Honor heard testimony in the Gutierrez-Reed trial that was exactly the opposite of that.
That's interesting. If that really happened that way, that's very interesting. Although remember, that is a separate case involving a different co-defendant, but it's the exact same fact pattern. God, if they really did that, oh boy, that's a little rough. That's a little rough there, Carrie. Oh boy.
We've quoted that testimony in the brief, Your Honor. Mr. Carpenter said actors sometimes view the safety checks, but that's for a warm and fuzzy feeling, and that's rare. He said sometimes.
Would that be Giglio material? Well, it'd be Brady material. It wouldn't necessarily be Giglio, but I would argue, yes, that's potential Brady violation. That is a potential Brady violation. That a Brady violation is any potentially exculpatory material must be disclosed. Now, in Hannah Reed's case, I think you'd almost be able to argue even more prosecutorial misconduct. So, guys, Brady material is Brady versus Maryland, and you guys have heard that before a bunch of different times. Giglio's because it's impeachment. Yeah, but so there's a couple of different cases here, guys. There's a couple of different cases. There's Giglio, there's Bagley, there's Kyle's v. United States. There's a bunch of cases, okay? And these are all criminal things. And ultimately anytime in Giglio here, so in Giglio, a guy was accused of forging money orders. Okay. Well, one of the guys agreed to testify against him, and it's part of that testimony he was going to get a smoking hot deal. And that was never disclosed to anybody. And the Supreme Court of the United States said, that's important because the failure to inform the jury the witness had been promised that wasn't presenting all the material evidence to the jury. And it violates guy's due process. So Giglio's, it's something you would use to show bias. Well, you've got a hell of a reason to testify and say this happened, don't you? In fact, you're selling this guy out to save your ass. So Giglio would be important here. I mean, you'd argue it's a Giglio violation, a Brady violation, a Kyle's violation. It violates Bagley. Those are all cases that have been in front of the Supreme Court. Yes, the cops who have liar reputations, yes, it kind of all goes down there. Now, because there's a separate issue, it's ultimately Brady. Brady's the ultimate one. And guys, we talked about this before. Brady versus Maryland. If there's exculpatory material, you are entitled to it. Now, Bagley and Kyle's are offshoots of that. And what did they do? It's like, well, how do you know it's exculpatory? Well, it's like anything that could lean towards the exculpatory nature So basically anything that appears to be exculpatory. You don't have to go, well, how did I know? It's like, if you're not sure, you disclose it. And a lot of places now, prosecutors try to save time and effort by saying, look, here's fucking everything. It's called open file discovery. You got everything you want. You want it, here you go. And most cases not bad because most files are not super voluminous as far as documents to dig through. But at least that way I could see everything. And you usually don't run into Brady material as much anymore. You don't run into Giglio as much anymore. But you always still ask for it. You demand everything, and you demand everything pursuant to. And you know what? Here, you know what? I'll bring up. Hold on. Do I have a? Here. So we'll bring this up real quick. I'll bring up just so you can see the stuff you ask for, because this is critical information. And even though I explicitly state it, when I demand all discovery, like so a simple discovery demands. In Ohio, for example, in most states, you could say, I demand all discovery that's entitled to my client pursuant to rule whatever of your state's laws on criminal procedure. Now, the idea for Brady material, that's already guaranteed under the Constitution and the constitutional law, that the state has to provide that stuff. So it's already assumed it's going to be there. Okay? But, and like I said, your discovery demand can be one sentence. And just boop, done. And it's got your caption, signature at the bottom. Or you can do it. You can be a little more in depth when you do it. Oh my gosh, why are you being so ridiculous? And you can do it. And I'm going to start with. So, like, here is. Actually, you know what? Hold on. I'm going to go back out of this for 1 second. We're going to go back to this 1 second. So I'm actually just going to block out all the names, and that way you guys can't tell anything. So. Okay. All right. So this is kind of like a basic what you're asking for in discovery. All right. You're going to ask for some basic things. So it's a request for written discovery. This is the basic one I use. And depending on the case, I may file a special pointed, I may request special things at times, just depending on what I'm looking at. So this is now comes the defendant by it through counsel pursuant to Rule 16 of the Ohio Rules of Criminal Procedure. Now that's the rule in Ohio criminal procedure that governs discovery. So in New Mexico, it's going to be different. But that's where you start. A request is made by the defendant for written discovery and respectfully demands all applicable discovery, including the disclosure of the following evidence. And now, see, all applicable discovery is good enough because Giglio and Brady are already there. But I just go ahead and ask for everything. And I just say, like, any written recorded statements by the defendant or co-defendant, any recorded testimony of the defendant or co-defendant before the grand jury, the defendant or co-defendant's prior criminal records, any summary of an oral statement by the defendant or co-defendant, or witness made to the prosecutor's office. You know, any electronic surveillance or intercepted communications, including wiretapping, of the premises of the defendant or of conversations to which the defendant was a party. All tangible paper. Oh, I didn't realize there was an extra space in there. I need to change that. That's embarrassing. Any tangible papers or objects, you know, any listing of tangible objects, like there's nothing wrong with like being fucking like, give me everything. You know, whether the state is material information that has been provided by a CI, all arrest warrants, search warrants, the names of any witnesses who the state intends to call, along with their prior criminal records. And then the names and addresses of witnesses who might establish the innocence, mitigate the punishment of the defendant, impeach the credibility, or contradict the testimony of a witness whom the state may call. Now, that's going to be a lot of Giglio and Brady issues there anyway, but then you just get back down to it here and you say any and all evidence favorable to the defendant and material to the guilt or punishment of the defendant discoverable under Brady v. Maryland, United States v. Bagley, and then Cowles v. Whitley. Okay? And you can see these are the years they had those cases. So Brady was the first, and then building off of Brady was 85, and then building off of Brady and Bagley was Kyle's, and that's 95. So, and then here you get to the contents of any promises, grants of immunity, guarantees, assurances, proffers, or agreements of leniency of any kind, oral or written, entered into by the state of Ohio, and that means by the prosecutor or law enforcement with any co-defendant or witnesses in exchange for their testimony to be used against the defendant, and that's under Giglio. So anything you've done to help somebody out is specifically Giglio material. So who's snitching? Who's talking? And then, I mean, it goes on here, and this is not a super huge one, but it's just the basics of what you're demanding. So that's what you're demanding. You're demanding everything. You're demanding all the things there. All the things. TLDR is about who cops who have a liar reputation. Yes, that's all. That's one of the biggest issues. How often do you hear about an indictment being overturned, especially if someone was also indicted or convicted for the same incident? Generally, you don't get indictments thrown out because the prosecutors don't fuck it up. I mean, it's really hard to fuck up an indictment. It's hard to fuck up the grand jury process. It's literally spelled out for you, number one. And number two, God, I hope I haven't been muted this whole time. Number two, when it comes to an indictment in the grand jury process, you can indict a ham sandwich. I mean, the prosecutor's doing fucking like they're making like 6-inch putts all day. It's fucking easy peasy, lemon squeezy. But basically, yeah, if Carrie didn't give Hannah that grand jury testimony that there's a witness who said something completely contradictory, maybe a new trial. You could argue it's a trial, but they might argue harmless error. Depends on how big ultimately. I mean, I'd argue it's pretty big, but yeah. Open file is the way it should be, yes. But even here's the deal. This prosecutor's office I'm dealing with here. This is in Cleveland, Ohio. This is the Cuyahoga County Prosecutor's Office. Guess what? It's open file, but I still ask for everything specifically. I don't fuck around. You know why? Because I don't ever want a prosecutor, and I haven't ever encountered one that does this, but, well, actually, you didn't ask for that. I want to be able to state, here's what I want. Give me everything. Now, this is an interesting topic. J-Rock is saying, Ag, I work with the police. You really are fed. I sit on charity board with the county police. There are a great many base police. Yes, there are police who aren't bad. I can't quit staring at the desk. Yes, I know it's bad. Michael Osbrook saying, no, the state does not produce that stuff, though it reversals several years later. Well, if you ask for it, they're going to have to. Good thing Alec Baldwin didn't go to traffic court. His lawyers might not have shown up. Ooh. Ooh. Oh, no, chat. Yes. No, that would have been rough. That would have been rough. Lucas saying, sorry for the tangent, guys. Thought the point was interesting. Yeah, no, it's all good. It's all good. All good, man. So we're going to keep going here. We're going to keep going here. Cosmo says, I don't get it. That's okay. Ask your mother. Ask your mother. She'll tell you when you're older. You're okay. So, but that's what they're going for here. They're going for what happened at trial here. And yeah, that's a very good point they brought up, that like this could be a big deal. Now that they know about it, though, that's a very big deal, because we want that witness. And guess what? If Carrie brings in the same lineup, whoever that witness was, and we don't know exactly who it is, bam, they're going to just like, well, you were called from the grand jury, right? You get grand jury testimony, yeah? What'd you tell the grand jury? Boom. And now you've got a competing witness, and that's a witness the state used. It's like, that looks really bad. Why is it not working? Why is it not clicking? Huh? What?
Actors say, nah, exactly the opposite of that. We've quoted that testimony in the brief, Your Honor. Mr. Carpenter said, actors sometimes view the safety checks, but that's for a warm and fuzzy feeling, and that's rare. He said, sometimes actors say, nah, his words, nah, I don't want to check the gun. And that's okay,
Yeah.
as long as you've checked it with the other sources, the other people who are responsible for
No,
checking
he's not
it,
been arrested.
not the
Yeah,
actor.
no.
It's the armor's responsibility for verifying whether the gun has live ammunition in it or not. And you heard Ms. Morrissey in closing argument say the armor's the autonomous decision maker. The actor is going to manipulate the gun. Of course he is. That's foreseeable. Your Honor, we do not think, as an officer of the court, a lawyer can elicit testimony from a witness.
Oh, real quick, chat. Michael Osbrook, if you are the Michael Osbrook that's been doing all the Richard Allen stuff, hello. Thank you for being here. If you guys don't know, he's been involved with the actual Michael Osbrook has been involved in the Richard Allen case. So if that really is you, sir, hello. Thank you for stopping by. And it's part of the, basically it's kind of like the, heck, I think it's even Twitter handles like the Indiana habeas guy. And he is the director of the habeas project at the Indiana University School of Law. So Indiana University, no slouch. So thank you for being here if you're here. No, the state does not produce that stuff, though, reversals years later. Yeah. That's why you ask for everything, and it sounds like they did a lot of good ideas on that. But thank you for and I'm not sure if you responded to me or someone else, but anyways, thank you for being here. So me too, Sean. I'm Michael Osbrook. Yes, you're all Spartacus. Okay. Thanks, guys. Thank you. Now you all guys are all going to change your name to him or something.
On these grounds saying X, and then 2 weeks later, procure a guilty verdict in a related case by having that witness testify not X. We do not think, as an officer of the court, a lawyer should be able to argue one theory to the grand jury and then in a related case, turn around and argue an opposite theory to obtain a guilty verdict. Just as an officer of the court, at a minimum. But to push it even further into the context of the grand jury process, all these cases.
The funny thing is he says that, but that happens all the time, that the co-defendants the prosecutors will make separate arguments. And they do that, though. That's, and I agree. I think that's not right, but that does happen. They will argue different theories of liability for co-defendants like that. So, but that's, there are, although to be fair, like, let's say you're doing like a felony murder, like a bank robbery. The guy who's actually in there shooting the gun, well, yeah, he does what he does, but the getaway driver, well, it's felony murder. It's an accomplice liability. So they would have different liabilities under different theories, but I think he's trying to argue completely and vastly different things where now the evidence has changed. And because I know it's somewhere you're thinking, it's like, well, wait, you could argue a different thing. He's literally arguing, though, the evidence is that different. We have a different witness, and a witness is something that changes the direction of a case. And if Carrie Morrissey really did hide that, and here's the thing, he might be wrong. He might be lying. Betting he's probably not, though.
Aurora, the grand jury statutes, they all say the prosecutor is there, as Mr. Spiro explained, they're not to be the grand jury, but to aid the grand jury, to ensure a...
And I agree with David. And I actually think a great example of this would be the Crumleys. When Jennifer Crumley went first and then the husband went second, they kind of used different theories of liability and responsibility with the same evidence there and presented. Should they have been able to do that? I don't think so. I don't think that should have been done, but they get to. So, yes, those are times where it's not fair like that. So, you can see my reflection on the guy's forehead. Jeez.
Fair and impartial process to ensure the grand jury hears the evidence that's contradictory. Lampman said, for example, if you put a prosecutorial witness up, a state witness, and that witness has information that's contradicted by another, you have to call the other. Lampman dismissed on those grounds. That didn't happen here, Your Honor. Exactly the worst scenario happened here. The same expert says X. 2 weeks later, the state has that expert say not X. That is not fair and impartial, Your Honor. That is not the presentation of contradictory evidence. It's exactly the opposite of that. That's number one, Your Honor. Related to this instruction, the premise of it, the history in front of Judge Ellington, and Your Honor has those orders and has that briefing. Number two, again, under the violation of the structural rules, the process, the state failed to advise the grand jury of its proper authority and role, and failed to correct the grand jury's inaccurate view or misunderstanding of its authority in these circumstances. The rules are simple. Grand juries required to obtain exculpatory evidence. The word under 31.6.11b is shall obtain, not may or might.
And remember, this is grand juries only in New Mexico. Grand juries otherwise are not required to have exculpatory evidence. So more than likely where you live, if you live in America, does not apply to you. Remember, it's only 5 states. So this is not for everyone.
And the prosecutor has an obligation to facilitate the grand jury's inquiry into that evidence. And again, facilitate is the word the courts use to describe this obligation, even above and beyond what the prosecutor decides to present. The prosecutor is there to be the aid to the grand jury, to ensure that the grand jury understands its role, its responsibilities. The state did exactly the opposite again. The state told the grand jury who the witnesses will be, not might be, not maybe, not the witnesses that the state intends to call, who the witnesses will be. And then the state reinforced this message by saying that the grand jury could consider the alert letter or just begin hearing witness testimony, without explaining the third option. Consider the alert letter, hear the state's witnesses, and, as Mr. Spiro explained, call the alibi witness out in the hallway and look at the movie ticket. That third option was never explained, number one. And number two, it's clear the grand jury had no idea that was an option at all. Because when the grand jury was asked, how do you want to proceed? They said, well, I guess if that's all our questions about this letter, and the question they asked, Your Honor, was about a typo, they said, I guess we'll begin hearing witnesses. In other words, the witnesses the state told them definitively they were going to hear from. And so the whole exchange in the grand jury transcript demonstrates that the grand jury did not understand the purpose of the alert letter, its obligations and responsibilities, and the state didn't correct them. The state never explained Baldwin's witnesses were available to testify. In fact, they weren't. Mom wasn't in the hallway. Even though Judge Ellington told the state, you need to arrange for the scheduling to make them available. The state didn't even call them, didn't contact them. They never intended to call these witnesses. We gave multiple examples, Your Honor, of briefing in our briefing where the grand jurors were asking for information that would have been answered by the SAG statement, by Dave Halls, by Sarah Zachary, the industry safety guidelines, Joel Souza, or any number of other sources. Instead, when the grand jury asked those questions, the state cut them off, exactly the kind of behavior in Herrera that justified the dismissal on this ground, presented testimony from a different witness, and oftentimes testimony that contradicted what a different witness would have said. Carpenter's the best example. Or Adigio. Adigio suing Mr. Baldwin, seeking money damages. And Ms. Morrissey put some footage on a screen for Adigio to explain. And as we've all seen, intervening cause is a material issue here. Judge Ellington required the instruction to be read if there was evidence to support it. The state read it. And so Mr. Adigio is testifying about the footage that the state had put on the screen. And he says, well, there are a number of things that I'm concerned about here. First of all,
now, if you guys remember, Ross Adigio is the guy who looks like Walter White. Had the red beard and is bald. He was the camera grip operator guy who was right there when Halyna Hutchins got blown away. Who's very mad and is suing, yes, and that's exculpatory. That goes towards bias. You know, motivations of a witness. You could ask, they could have demanded that you ask of this person, is it true you're suing Alec Baldwin currently? Well, yes. That gives the grand jury the ability to weigh the evidence and make a determination.
as soon as Mr. Baldwin emptied the firearm and we had to reload it, Dave Hall should have called cut to give everybody the moment to safely reset. It appears as though, he continues, the armor is putting spent ammo in the same fanny pack or pouch as live ammo as she's pulling live ammo out.
And that's the part we talked about, guys, when we read the motion. They never even bothered calling the witnesses. Like, Carrie Morrissey's like, yeah, fuck all this. I'm not doing it. And those witnesses were ready to go. It wasn't like she could say, well, I don't know where to find them. Alec Baldwin's team had those people ready to go. They were going to come in. They were ready to testify. They were available. They just needed to, they just needed to be told to show up when and where to sit. And they would have showed up. So it's not as though it's like they got to go find, Hobo Jim somewhere in Albuquerque. Nope. Here's a list of people. We want them to testify. You need to present them. Just let us know when it's time. And, here, just tell us. We'll make sure they show up. Here's our contact info. And Carrie's like, fuck it. If she did it like that, that's going to be a big problem. And that's going to be something I'm curious to see what Carrie argues that why they didn't do it. Hobo Jim does not approve. Thank you. Well, sorry, Hobo Jim, if you're out there. I've always been fond of it. I forget where I heard this before, but Joe shit the rag man. But I forget where I've heard that before. So here we go. Can we all agree that Alec's an asshole? Yeah, sure. That doesn't mean he's should be illegally shanghaied. Because if they'll do this to him, imagine what they'll do to you. 10K view says, so the DA was a bit sloppy in the grand jury process? ? Yeah, just denied? Yeah. I mean, sloppy is sloppy. If he had rights and they were violated, yeah, justice was denied. Suiar says Bronca has high praise for Morrissey, though. Yeah, Carrie Morrissey is a phenomenal defense attorney. She is a phenomenal defense attorney. That doesn't mean you're necessarily going to be a good prosecutor. I mean, it helps, but everybody kind of fucks up. And if it's not your thing and you're not experienced at it, if you spend all your time, like if you're at a 5-star restaurant or a Michelin-starred restaurant, and you spend all your time running the lamb sauce, and then, Chef Ramsay makes you start doing the risotto, you might suck at that initially. Power corrupts? Maybe, maybe not. I don't know. I don't want to get that far because I'm not going to attribute that to there. I'm just going to think she just fucked up. So, Bronca has high praise for a lot of stupid things. Yes, I don't agree with many of the things that Bronca has made rulings on, but yeah. Patty says, is this only because Alex got good attorneys? No. I'm sure if you got some public defenders in New Mexico, they know the process. The problem is when you're in New Mexico, you might not be afforded counsel at that point or have the right to counsel because let's say they indict you and you get indicted directly. You get the targeting letter. Okay, but you might not necessarily be entitled to indigent defense at that point. I think you probably can under New Mexico law. I'm not sure how that works, but I also might be prepared to find out you're shit out of luck till you're actually indicted. It really depends. Really depends. I don't know the answer to that. And that's actually something I wish I knew the answer to. Because I actually have searched out that answer is in New Mexico, once you get the targeting letter, are you entitled to indigent defense? And I'm assuming the answer is no. But if you had a couple of public defenders with you, could they make this argument? Oh, 100%. The point is, though, this argument wouldn't have any merit because you didn't present anything to the grand jury in time as a private citizen. So that would be the shitty part. Let's say Alec Baldwin couldn't afford anybody. Well, yes, public defenders would be like, yeah, you kind of got fucked at the grand jury, but hey, look, it's not your, you weren't entitled to representation, so we can't help you. Tank said make a great point about indigent defense. Well, it's very limited area you're entitled to it. And that's probably doesn't count. But yes, it helps he's got attorneys involved. If you have attorneys involved, they generally know what they're doing. And yes, he's got really good attorneys, and these guys have staff. They've got interns and paralegals and junior associates and the weight of an entire multinational law firm behind them. A little bit different. But also, if Baldwin had hired me out there and I would know the rules in New Mexico, I could fight the same way. So, anyways, here we go.
Out of it. You kind of went past this for a moment, Adigio says to Ms. Morrissey. Dave Hall's the first day.
That guy, sorry.
Dave Hall should have called cut to give everybody the moment to safely reset. It appears as though, he continues, the armor is putting spent ammo in the same fanny pack or pouch as live ammo, as she's pulling live ammo out of it. You kind of went past this for a moment, Adigio says to Ms. Morrissey. Dave Hall's the first AD who is in blue jeans and a black shirt is not. Ms. Morrissey cuts him off. He's explaining intervening cause. I couldn't have dreamed of better testimony to start to explain intervening cause. Ms. Morrissey cuts him off in the middle of it. And after she had already taken something off the screen that he was trying to explain, and she says to him, and keep in mind, we're here for Mr. Baldwin. Point your narrative. What is Mr. Baldwin doing in this scene that we watched and anything that happened after when the camera turns off? Because we're not there. That's concerning you. That's exactly the kind of conduct, cutting off a witness, withholding evidence a witness is about to give. That ground alone in Herrera was a basis for dismissal, independent of anything else, that one thing. And that's because the whole point of the grand jury process, as Judge Ellington explained it in some of his orders, to give the grand jury more, not less. This is exactly giving the grand jury less on a critical issue of intervening cause. And then as we explain in our brief, Your Honor, there are examples of where the grand jury misunderstood evidence and said, Mr. Baldwin refused to check the gun. And then he got the gun. How would he check it? Would he shake the bullets? Would he put them in his hand? A question that has no premise in the evidence and is not accurate. Instead of correcting that misunderstanding, instead of having a witness who could explain Mr. Carpenter, as he did in the Gutierrez trial, saying the actor has no responsibility, she cuts it off She calls Mr. Carpenter, who testifies exactly the opposite of what he testified under oath in front of Your Honor in the Gutierrez-Reed trial. Mr. Baldwin was responsible for checking the firearm and verifying whether it had bullets. Exactly the opposite. These are things that Herrera dismissed the indictment for. And when you look at the grand jury record, that first point I made about the grand jury's understanding of its role and responsibility, there's literally nothing in the grand jury record, nothing in the transcript to show that the grand jury was informed of its obligations and responsibilities. The state says, well, that's the court's responsibility. Judge Ellington should have done that. Well, there's nothing in the record to show what they learned, what they received, and how they were told about their responsibilities. The state didn't do it, and the state didn't correct it when it was clear they didn't understand. And the Willoughby case, Your Honor, dismissed for exactly this kind of reason. In Willoughby, the state argued that the grand jury was given a grand jury instruction manual, apparently from the description of a big pile of information that had all the things the grand jury could ever want to know about: its responsibilities, its roles, all the different kinds of crimes that exist, the elements of the crimes, everything you'd want to do to instruct a grand jury about how to be a proper grand jury was in that manual. But the state, when it came time to read the jury instructions in the Willoughby case, just referred the grand jury to the manual and showed them how to use it and said, go there, and that's where you'll find the instructions. The court dismissed the indictment on this ground. Didn't have to prove prejudice, didn't have to prove materiality, because that violated the process. Why did it violate the process? Because the court explained in Willoughby, it's the prosecutor's obligation to act in a fair and impartial manner. It's there to ensure that the grand jury received all the information it was supposed to receive. And the grand jury was supposed to be aided by the prosecutor in doing that. And there was nothing on the record, even though the prosecutor said that they gave the grand jury this manual. And even though the grand jury was supposedly told how to use it, there was nothing in the grand jury transcript that gives us or gave that court confidence that the grand jury had been properly instructed. Nothing in the transcript. And the court said that alone requires dismissal. If you can't, in the four corners of the transcript, find those instructions and have confidence in this indictment that the grand jury knew its role and responsibilities, then that's the end. Dismissal. No materiality required, no proof of prejudice, no proof of bad faith. In the State versus Hill case, we talk about grand jury secrecy. We read in the New York Times when the grand jury date would appear. The New York Times reported that Ms. Morrissey had conducted an interview, explained that the grand jury would take place on November 16th. And there was a lot of other comments about the firearm and the trigger, things that the prosecutorial rules of ethics don't allow prosecutors to say. Focusing particularly on the grand jury date, but also the rest of it, but on the date, we look at State versus Hill. State versus Hill had a special prosecutor involved, and that special prosecutor had not been properly appointed. Therefore, when the special prosecutor was in the room of the grand jury presentation, there was an unauthorized person in the room. The court said, end of story, indictment dismissed. Why? Because the grand jury rules need to be enforced rigorously. Secrecy is a vital requisite of grand jury procedure, quote unquote.
And that is a critical thing. You can't have random people in the grand jury room. That's a very true statement. That will immediately blow up a grand jury indictment. That's a fatal indictment. That's a fatal flaw. That's a structural error.
State versus Hill. The fact that there was an unauthorized person in that room meant that the secrecy rule had been violated. Highly, highly technical. No proof of materiality. No proof of prejudice. Didn't matter. We safeguard the system. Secrecy is a vital requisite.
Why does his mic suck so bad? Guys, because he doesn't stream. He's using a webcam and using the webcam mic. Because what I'm doing here is not his job. He's out, like Phil says, full-time lawyering all day long. So that's why. That's why. Him and I are not alike.
The state disclosed the grand jury date to the New York Times in an interview. We've cited the article. That breached the secrecy rules. So did a number of other comments. You have all the briefing in front of you related to that. That alone, as Judge Ellington said, could cause significant prejudice, which we don't have to prove anyway. But Judge Ellington said, I am deeply troubled. The world knows this grand jury date. I don't want to read the New York Times tomorrow about anything that's happened here. Clearly, he had read the New York Times before and saw that interview. Because there are members of the grand jury coming to me, at least one, coming to the clerk and saying, I want to sit on the Alec Baldwin grand jury. That's entirely unacceptable, highly prejudicial. That's exactly what State versus Hill was getting at. You violate the secrecy rule, which that interview did by disclosing that date to the New York Times. That's the end. Rigorously and strictly enforce the rules. And this whole process, Your Honor, violated the rules from start to finish. The secrecy rules, the court ordered that witnesses be available. They weren't made available. They were not called. They were not scheduled. The state went on multiple media shows and made.
And guys, I will say, we talked about that when we looked through the defense's thing. Jurors showing up saying, can I be on the Alec Baldwin grand jury? That's that's a big problem. It's a big problem. You don't want people knowing what's being presented. That is a big deal. It's a massive problem for a grand jury. So, but just and grand jury is good for adhered as well by the judge basically asks basic questions. But yeah, it's a bit of an issue.
Statements that violated the grand jury secrecy rules in violation of the ethical rules as well, governing the statements that prosecutors can make, which Judge Ellington expressly called out, as I mentioned. And we actually learned just this week, Your Honor, that the state paid Brian Carpenter to go on multiple TV shows, including the Sean Hannity show, to disparage Mr. Baldwin, make comments about his ultimate guilt, saying he pulled the trigger, had a duty of care, saying the prosecution was doing an excellent job.
They just found out that happened? Woo! I'm sorry, I didn't mean to. That's really bad if they're doing that. Their expert witnesses are sending around like that if they really could prove that. Ooh, lad. Ooh, lad. That's not good, chat. That's not good. Also, by the way, yeah, it's after hours. I gotta put something a little more relaxing. But dump the shirt. But yes, apparently Hannity's still on. You're a great American. I clean tables and I'm an expert. Yeah, fuck you, Sean Hannity. But yeah, if they really did this, oh God, that's. Oof. There's so many guys. Here's the deal. There's so many, and this is probably why I'm a bit of a, probably compared to some of these attorneys, you see the shit Harvey Specter does, or you pick any attorney like that. There's so many things I hear in these cases, where I'm just like, oh, fuck, I am not. I'm like, there's no way in fuck I'd do that in a million fucking years. Like, why? Why would you do this? Who went on Hannity? The armor, that guy who testified, who ran the armor company, the younger guy, who had been on set with all those different people. There's so much stuff from fuck, God, I wouldn't do that. I mean, TV law shows aren't real. Yeah, but I'm just saying in general, you see attorneys doing this kind of shit in real life. Like this, if Carrie Morrissey really did that, fuck. Like, honey, how did you not know you couldn't do that? How'd you not know you can't do that? What made you think that was a good idea? Whew. That's misconduct right there. That's a misconduct by the state, if that's true at all. Yeah, that's what I mean. If Carrie paid him to do that, Ooh, that's where that's why I was like, ah, oh no. Yeah, I'm a little, get the fucking vape. Like, I'd be like, Your Honor, I'm sorry, it's a little hot. It's like, you're breaking up. And I'd be like, Your Honor, I'd be leaving like that if that happened and they found I did that. So, oof.
He pulled the trigger, had a duty of care, saying the prosecution was doing an excellent job, not disclosing he was a paid expert, being paid to go on a TV show to disparage Baldwin by the state. And so that's the second ground, Your Honor, for dismissal. No prejudice required. The third ground is that the prosecution acted in bad faith, which allows the court to review sufficiency, and the judicial review of the indictment and the evidence demonstrates that it should be dismissed. Now, number one, the state, again, cited no cases on this other than saying bad faith is required. On this standard, we agree with that. That's not the standard for the second ground. It is for this one. If you look at bad faith, Your Honor, bad faith is defined very broadly. It's dishonesty of purpose, belief, or motive. And we've cited numerous examples. I won't belabor the court today. It's all in our briefing, pages 36 to 38, for example, of our opening brief. Several examples of dishonest belief, purpose, or motive. Things like granting the 48-hour deadline to Gutierrez Reed, and on the same day saying to Alec Baldwin, you're not going to get that 48-hour deadline, even though we've never seen this done before. Those are the sorts of things that in the aggregate and individually are sufficient to show a motive, a purpose, a belief that we believe opens the indictment to judicial review. So is Carpenter's testimony. Having a witness testify one thing in one trial and then the opposite in one presentation and the opposite in another shows dishonesty in purpose, belief, or motivation. Your Honor has all that. I won't belabor it. When you look at the evidence and do a judicial review of sufficiency, it's important to look at a few different examples. Again, I won't belabor the point. It's all in our briefs, but I want to highlight two things. The state called Detective Hancock. The state called Detective Hancock, and at the same time, she was on Mr. Baldwin's list of witnesses that we submitted to Judge Ellington and believe should be called to testify in front of the grand jury. Judge Ellington said, if you call any of these witnesses to the state, you're not required to ask word by word the questions that Mr. Baldwin put in his attachment to the alert letter, but you are required to elicit the information from those witnesses that Mr. Baldwin is intending to elicit so the grand jury can hear it. When you look at Detective Hancock's testimony, Your Honor, what you'll see is that Detective Hancock gave very tight testimony under very tight questioning from the state. She said Mr. Baldwin was required to do the safety checks of the gun, even though Detective Hancock had been specifically told by certain witnesses that he wasn't required to do that. She testified that the investigation was perfectly proper, the crime scene was secured, etc., even though there was specific evidence in the state's files from Chilling, for example, that it wasn't. She was asked a number of questions, very tightrope, that did not elicit the information that Mr. Baldwin argued should be elicited, and Judge Ellington approved that. So if you look at that testimony alone, Your Honor, you will see a violation of the requirements of Judge Ellington's order and New Mexico law. The state put Carpenter on the stand. You've heard the contrast as I've described it. The case law is very clear, Your Honor, that when you put a witness on the stand, a state witness, and that witness, a law enforcement witness, a law enforcement expert, gives testimony, you're required to put on testimony that contradicts it. The state doesn't do that. We've put all this evidence in our brief, Your Honor. Your Honor has the grand jury alert letter with that, so I won't go through it all. But the bottom line is that the list of evidence that the state had in its possession, did not elicit, and should have elicited is significant. Its own gun expert testified the FBI broke the gun, no signs of modification. Admits in the Gutierrez-Reed trial that the firearm shows evidence of rough tool marks on the hammer. We could go on and on, Your Honor. The point is there's significant evidence that was not presented to this grand jury that should have been elicited from Detective Hancock, that should have been elicited to Carpenter, that contradicted the evidence the state had presented at the Gutierrez-Reed trial, that upon review in the aggregate, we believe is more than adequate to show this indictment should be dismissed when you conduct a review of sufficiency. And so those are the three grounds, Your Honor. I'll stop and ask if you have any questions, but otherwise, our briefs detail this extensively, so I'll rest there.
All right, thank you. I'm going to basically take a bathroom break, and we'll get back on here. So it's 10:47. Let's return at 10:55, okay?
Thank you, Your Honor.
She's like, I gotta go take a pee. So she's just like, I gotta go, chat. So this is the last, I heard this last, probably the last 15 minutes of this. And then there was this kind of break in here. So now it's Carrie Morrissey's turn. So let's hear what Carrie Morrissey's got to say in response.
I am. Thank you, Your Honor.
All right.
Also, you guys are kind of making fun of him because he's got like boxes in his office. Guys, that's, there's boxes around, like, the attorneys' offices are not spotless. Like, there's shit everywhere. I mean, like, it might be nice and organized and neat, but like, yeah, I've got crap, like, even here at home. I've got work and it's sitting in different things, all kinds of stuff. I'm not going to show any of it because it would show things about clients. But yeah, having boxes of files and stuff around, no big deal. That's a clean office. And I bet he cleaned it up a little bit for camera. Hutto says, I hope he sees this. Why? I think he's done a good job so far. He laid out his arguments. He did a great job. Let's see what else he's got. Not her shove him out of frame, but why shove him out of frame? It don't hurt nothing. Do I use this Schmancy setup for Zoom Court? I do. I do use this, but you know what I do? I blur everything the fuck out. I blur it all out, chat. Yeah, there's some things you can't, but back in the day, 10 to 15 boxes of files, yeah. So here we go.
Thank you. Go ahead, Ms. Morrissey.
Your Honor, thank you. So I want to begin by briefly addressing the initial comments by Mr. Spiro. Mr. Spiro seems to think that there's something wrong with the fact that the case was dismissed and brought back. There's absolutely nothing wrong with that. That was an independent decision made by the special prosecutors because Mr. Nikas asked us to do that. That is exactly what happened. And his ask was not unreasonable. We did it because Mr. Nikas came to us and said, hey, it doesn't seem fair that this case continue to hang over my client's head while you guys are waiting for forensic testing that could be dispositive. So would you do the right thing and dismiss it without prejudice? We agreed to do that. So any complaints that the case was dismissed and brought back are an absolute misrepresentation of the history of this case. The issue with regard to the removal of the 48-hour language in the target notice, I've never fully understood what the concern here is. This isn't something nefarious. This is something that the state did because we intended to ask the court for a scheduling order under 5302.2, subsection D.
Because it seems sketchy, Carrie. That's why everybody's pissed. That's why. Like, I don't get the big deal. It's like, we can tell you don't get the big deal.
Which has since been removed from that rule. But it certainly was in the rule at the time that we were dealing with this, because it struck us that this case was going to require that the court have enough time to consider all of the legal issues, and 48 hours was not enough time. Keeping in mind that we served Mr. Baldwin with his target notice approximately 3 weeks before the grand jury date. So we had created a situation where there was going to be plenty of time because the rule contemplates 10 days. The rule contemplates that the defendant receive his target notice 10 business days before the presentation. We gave it to him 3 weeks in advance. We asked the court for a scheduling order. Under the rule that allowed us to do it, the court declined. We understand that. We never asked the court to give Mr. Baldwin any less than 10 days, which is what the rule contemplated. There's no problem with that. If we had included the 48-hour language in the target notice and then filed a motion to modify it, the complaint would have been that they relied on the 48-hour notice in the target letter. So we removed it, told them we removed it, told them why we removed it. There's nothing nefarious about that. You know, we asked the court to permit a minimal voir dire of the grand jury because of the tremendous amount of press coverage that the case had received. We were open to having a conversation with defense counsel to see if we could come to an agreement about, just like somewhere between 5 and 10 questions to make sure that we had grand jurors who weren't prejudiced against either side based on all of the press coverage that they've seen. The defense didn't really object to that. What the defense did was they filed a motion saying, we want to ask these 100 questions. I mean, they wanted to do a voir dire that would have been a trial voir dire. And at that point in time, it was clear that we weren't going to be able to work together in order to craft a few questions to make sure that all the grand jurors were good to go. The court denied our motion. We didn't do it. There's no prejudice there. There's no problem with any of that. We asked the court to let us do something. The court said no. We respected the court's ruling. That's not evidence that a fix was in. It's not evidence that there was anything nefarious going on. Mr. Nickus has continued to, and Mr. Spiro supported it today, he has continued to indicate that there was a statement that they claim to be attributed to me that came out, I think, on the Today Show. That statement has never been attributed to me.
I'm pretty sure it has.
Mr. Nickus has just continued to cite to a Today Show or an NBC News story and say that for some reason he thinks that I was the source that provided the information. He's never demonstrated that that was me.
I'm pretty sure it's been attributed to you in the written articles. Pretty damn sure it's been attributed to you. So. Bella, we'll see, because remember, this is both sides trying to give their accounting of the story. So we'll see. Yeah, that's what I mean. It's literally written down that it's attributed to her. The humbling remark. that is like, it's literally written down, I'm pretty sure, somewhere. I think we even covered that in an article. It's a cited article. Because a meeting never lies, right? Well, at that point, it's like she needs to say, I never talked to that person. They're lying. But if it's written down, it's like, well, I think Carrie was speaking a little flippantly and got a little loose on the lip and said shit. Yeah, so let it be written. God. Anyway, here we go.
I don't think in my entire life I've ever used the phrase teaching moment. I don't think I've ever even said that in my entire life.
Okay, see now, ooh.
So when we
Now that, see, and that's where you get this language. I've never said that ever. Because guess what happens? You're like, I'm never. Never is a very powerful word. Okay, well, now I'm not talking about now, Michael. I'm just saying, never and always are two of the most dangerous words in the English language. Never and always are very dangerous words. So, that's all I'm going to say.
filed our response to the motion to dismiss the grand jury, quite frankly, I didn't have a lot of disagreement with the controlling case law. I don't disagree that Herrera is a case that should be reviewed by the court. I don't disagree that Jones is the controlling case, both of which are actually cited in my brief. I referred.
Hey, Rock, this is guys, I need to step away for 1 second, but let this hang in the air. Mark Furman found out. Never is a dangerous word. Mark Furman found the fuck out. So, I'll be right back. Give me 1 second, guys. I gotta go take care of something. All right, here we go, guys.
To Judge Ellington's order citing Herrera and Jones. So when Mr. Nikas tells the court this morning, we didn't cite to a single case, that's not true. We talked about Herrera, we talked about Jones. We've given the court a little bit more information in our request for supplemental briefing with regard to Herrera. We cited to 31-6-11A. We cited to UJI 14231. That is the controlling law on this issue. We discussed it, we cited it. Where we disagree with the defense is on the facts as they have presented them to the court. So as a threshold issue, the court has to find that there is bad faith on the part of the prosecution before conducting a review of the grand jury. In support of bad faith, the defense seems to rely on the Herrera case, but I don't think the Herrera case is, hang on, let me get to,
Uh-oh, did she mess up her spot?
in terms of bad faith, the Herrera case found bad faith on the part of a prosecuting attorney. But in that case, the prosecuting attorney ordered the target not to answer a direct, relevant question from a grand juror. That is not at all what happened during this grand jury. The attorney also, in that case, told the grand jury that the target's testimony should not be considered because it was an impermissible attempt to make the grand jury consider the consequences of its decision to indict. That is not what happened in this case.
Well, it may not be.
I agree that Herrera should be reviewed by this court. But the facts, as presented, don't support a dismissal of the indictment based on Herrera. Herrera is completely distinguishable, and Herrera was cited in our brief. In the Baldwin grand jury, we had witnesses who were not at all familiar with how safety protocols work on movie sets, because hardly anyone knows how safety protocols work on movie sets. Detective Hancock, a grand juror, posed a question to Detective Hancock about the specifics of how safety protocols work on movie sets. I decided to have another witness who actually understands how those safety protocols work answer the question. I didn't hide any.
Then what should have happened is Detective Hancock, because that's not an impermissible question. Detective Hancock should have been asked that question, and then Detective Hancock should have said, I'm not trained in that. I don't know the answer. For her to jump in and say, we're going to go somewhere else. No. It should have been asked. And then let Detective Hancock say, I don't know. I'm not a SAG person. I'm not a movie trainer. That's how that should have been handled. That's how she should have handled it.
Information from the grand jury. I certainly, when I did that, my intention, since we're talking about bad faith, was to ensure that the grand jury got information that was accurate and reliable. And they were going to get accurate and reliable information from the guy who's an expert in movie set safety, not from a Santa Fe County Sheriff's detective who doesn't know anything about set safety on movie sets. That's not an example of bad faith. Mr. Nikas has tried to convince the court that somehow there's something wrong with Mr. Carpenter's testimony, and that his testimony before the grand jury in this case is somehow supportive of a nefarious intention on the part of the prosecution. I have reviewed Mr. Carpenter's testimony from the trial. I have reviewed Mr. Carpenter's testimony from the grand jury. Carpenter's testimony in the Gutierrez trial is that the armorer is in charge of gun safety. We agree. He also testified to that before the grand jury. Mr. Carpenter's testimony in the grand jury was that the actor has responsibility for the firearm once it is in his hand. That is absolutely accurate. I have gone through and pointed the court numerous times to the safety protocols for movie sets. And what they say is the person who's holding the gun isn't supposed to point it at anyone. The person who's holding the gun is supposed to keep their finger off the trigger. The person who's holding the gun is supposed to know what their intended target is. All of those are things that Mr. Baldwin failed to do. And that information was appropriately presented to the grand jury in this case through the testimony of Mr. Carpenter. The defense wants somehow to try to convince the court that the actor who is holding a real gun in his hand has absolutely no responsibility for what he does with that gun. And it's simply not the case. And it's not the case when you look at at Mr. Baldwin's own guidelines from the Screen Actors Guild. So we're presenting the evidence that we have that supports the charge. In addition to doing that, we presented this grand jury with lots and lots of exculpatory information about Ms. Gutierrez's failure, about the source of the live rounds. That is the proximate cause. The proximate cause issue that the grand jury absolutely needed to hear about and understand is Ms. Gutierrez put a live round in the gun. And Mr. Baldwin didn't know that there was a live round in the gun. That's proximate cause. And that was presented to the grand jury because I agree, it's exculpatory. It goes directly to the proximate cause jury instructions that they didn't have to argue with us about. We gladly presented those jury instructions to the grand jury. And I can't imagine a world at trial where we're going to object to those. There's not bad faith here. There was no testimony at any point in time, not in the grand jury, not at the Gutierrez trial, that the actor is required to participate in the safety check with the armorer and the assistant director. Nobody ever said that. It's not true. It's his option, and he declined to take advantage of it. We are presenting the facts to the grand jury as we see them. With regard to Mr. Nickus in his motion goes through this series of bullet points that he believes are related to bad faith. And one of those that has been discussed today, probably the only one that's actually relevant to the grand jury, is the information or rather the interview. I wouldn't call it an interview, but I did provide the New York Times with the date of the grand jury. I've acknowledged that. I've never tried to hide that. Honestly, I absolutely understand that grand jury proceedings are secret, but the date of the grand jury, this isn't a federal grand jury. The date of the grand jury proceeding is given to witnesses who do not have an obligation to keep it secret. They don't sign an oath. They have no obligation to keep that secret. It is given to the target. The target can give it to his wife. He can give it to his parents. He can give it to his wife's hairdresser. He can give it to who.
Now, in her defense, that is actually a true statement. Federally, it's different. At the state level, I mean, yeah, if there's no requirement to be silent, you could tell people. I've told you guys, in Ohio, there's some counties where the grand jury meets every day, some days once a week, some days once a month. It all depends. I mean, I could tell you when, if a county's grand jury is meeting next Monday. Am I breaking the rules if I know that? And I just know that because it's a matter of that's when they do it. I get where she's going with that, but blabbing it out to the New York Times is a prejudicial issue, I would argue. Is what I think she doesn't understand or is refusing to acknowledge. But they're not told who it's for, and I agree. I agree. You wish my audio was louder? I mean, I don't know how much louder I can make it, but I will turn it down a little bit. If you need guys, if it's too loud, tell me. We'll turn it down a hair. Here we go.
Whoever he wants. The date of the proceeding, in my opinion, is not secret. But best case scenario for Mr. Baldwin, let's say it absolutely is. The date specifically is something that nobody's ever supposed to know about, even though we give it to a whole bunch of people. The grand jury didn't happen on November 16th. The judge moved it. He moved it because he needed more time to address the legal issues. And that was the reason that we asked for a scheduling order in the first place. So the grand jury was moved from the 16th.
That doesn't excuse your and notice that right there shows you she knows she probably shouldn't have done it. She's like, but look, it didn't matter anyway. I think that's her way of tacitly admitting she knew she shouldn't have done that and she shouldn't have blabbed about it. Because she's like, look, it didn't matter. It didn't happen anyway. Actually, I think it's her way of trying to admit she shouldn't have done that.
Mr. Nickus has continued to try to argue in his pleadings, although he hasn't seemed to argue it much this morning, but he seems to argue in his pleadings that after that, I again provided the grand jury date to the press. Absolutely not. That absolutely did not happen. So, and I can tell you, Judge, it wasn't bad faith. It was just my understanding of the fact that everybody ends up with the date. A bunch of people who are not required to keep it secret get the date. And if that was a mistake, it's my mistake, and I'll take responsibility for it. In terms of the waiver issue, all of the cases cited by Mr. Nickus are civil cases. But again, they presented the case law that we agree is the controlling case law. We simply disagree with their recitation of the facts. So I filed a response that was largely my recitation of the facts. I do want to say with regard to Herrera, paragraph 20, our grand jury statutes require that the prosecuting attorney alert the grand jury to the existence of target offered evidence and do not require the prosecutor to actually present such evidence. Once alerted to target offered evidence, the grand jury remains free to decide not to hear the evidence or to hear the evidence and weigh it as it sees fit. So despite that is the law in the state of New Mexico, the defense continues to argue to this court that our failure to, one, notify the grand jury of their obligation, or not their obligation, but notify the grand jury of their power to call witnesses and review documents was somehow inappropriate. And in addition to that, the argument that we didn't call their witnesses We didn't present the testimony that they wanted us to present. We are not required to do that. We went above and beyond in this grand jury proceeding, providing to the grand jury. Not only did I read the target letter in its entirety, word for word, I gave each and every grand juror a copy of it. They had it the entire time we were going through the presentation. We didn't take those copies back. We left those copies with the grand jury the entire time, so that if at any point in time they wanted to reconsider and they wanted to say, hey, we'd like to hear from so-and-so, they had it with them the entire time. What I've always been a little mystified, other than reading the entire target notice and giving each and every grand juror a copy of it to read, asking if they want to take a break to consider it, giving them time to consider it, waiting for them to knock on the door, coming back into the room and saying, how do you want to proceed now that you've had time to review the target notice? And them saying, let's proceed with the witnesses you have. What, other than that, what am I supposed to do? And in this regard, if the court will indulge me, to a certain degree, the defense has misconstrued what Judge Ellington ordered when we had our hearing on January the 11th, 2024, prior to the grand jury. I would like to play just 5 minutes, a 5-minute audio of that hearing, so the court can understand exactly what Judge Ellington ordered and the back and forth that we engaged in. Would the court indulge me 5 minutes?
Her presentation not as good, but if she's I mean, yeah, guys, look, her presentation might not be as good. And you know, here's the thing, J-Rock saying they at least cited cases. Well, she could cite cases. She's like, I'm citing the actual rules. Here's what the rules say. Sometimes that's more. You can cite all the cases you want, but if the rules of court, the rules for a procedure, the rules of criminal procedure, the rules of jury instructions, the rules on how to conduct a grand jury say A, B, C, D. And you could cite the rules. The rules are very important. Remember, the cases tell you how to interpret the rules. But if you comply with the rules, you've got a bit of an upper hand there. Well, for her, she's making the argument of, I did everything I was supposed to do, and in fact, I did more, and now these guys are fucking complaining about it. So yes, if that's truly what happened, I would be pissed too. I'd be very mad. I would be very, very mad. So, yes, so now she's going to bring up she needs a giant ugly desk too. Yeah. Yes, but that's... Yes, her voice hurts my head. I understand. Luke said that's just a straight up lie. He mentioned a DUI case in this very hearing. That's what I thought too, but I didn't remember. So, civil counts of criminal doesn't exist though, right? So the way it works is, like there's criminal laws of procedure and then there's civil laws of procedure. Okay, so they have their own tracks. If something happens in a case, most cases criminal procedure, there's a rule for it. Most civil cases, there's an applicable rule. Now, generally, when you encounter something in civil procedure, you don't usually go, there isn't a rule for that. That wouldn't apply. Or we're in uncharted territory. In criminal law, though, doesn't happen all the time, but it happens enough that every once in a while you're stuck with, the criminal rules don't actually say what do we do here. Once that happens, you then take a look at the civil laws, the civil rules of procedure. Might give you a basic idea, and I've done this before, where you're like, look, Your Honor, yes, but Rule 42 of the civil rules states this, 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 and here's a bunch of civil cases that talk about how courts handle the matter. And you offer up that next step. Yes, you would use the civil arguments as persuasive. They're not binding, but they would be a persuasive and directional and advisory. You'll use what you can. But I have the feeling, and it sounds like there's criminal stuff on point. So it's not necessarily you have to, but you can use, basic questions of law arch over criminal and civil. So you can cite civil cases too. You're not in trouble if you do. Dabney Coleman died today. Oh, wow, that sucks. So that's we'll keep going here, guys. I don't want to keep breaking this up. We're not getting too far yet.
Mr. Nikas, Mr. Spiro, what's your position? Spiro, I'm sorry.
Yeah, I would object unless we're putting in the whole transcript, and she can submit it to the court in camera. I don't think we have to sit here and see some snippet of it, and then I have to redirect. I would have to the court just review it in camera if the court thinks it's necessary. I know the court has the transcript.
I think that's actually the proper way to make the argument here, because then he's got to be like, well, I don't have the fucking recording, and then I got to dig through it. Yeah, the rule of entirety. You got the whole transcript, judge, make your decision.
I would also add, Your Honor, that none of this was presented in the context of the opposition brief. So the request for full context, the full transcript argument on this would be highly prejudicial if it were going to be this focused and narrow.
I'm aware of the, I've certainly read the log notes and listened to the log notes of Judge Ellington's order. So make your point, Ms. Morrissey. I don't need to be refreshed. Thank you.
So the point is, Judge Ellington asked the grand jury clerk to provide refreshed copies of the grand jury orientation instructions so that the grand jurors, even though they had already had all of that information in November, even though they already understood that they could call witnesses, that they could subpoena documents, Judge Ellington had the grand jury clerk give them those instructions again so that they would be refreshed about what they can do in the grand jury, the powers that they have, the witnesses that they can call. There is no obligation on my part to start explaining to the grand jury something different than what the court has already provided them. They were provided those as a refreshment. And that explained everything that they could do. They understood their powers. I had a discussion with Judge Ellington about the fact that obviously, because this decision is coming, I think, less than a week before we're presenting the grand jury, that there would be some witnesses that we wouldn't be able to get there. We weren't going to be able to get out-of-state witnesses there. I had this entire discussion with Judge Ellington because I had concerns about it. And I asked the judge, if they want to hear from a witness and I can't get them there by the time the term ends, what's the best thing for me to do? Are we going to ask the grand jury to stay together, to come back on another day? Judge Ellington said that's a possibility. If any of these problems arise, I will be in the courthouse because I'm going to be in trial. Just come and speak to my staff. And if I need to render assistance, I'll render assistance. The grand jury never asked to hear from the witnesses. There's nothing I can do about that.
Well, that just led to everybody stunned in silence. She stunned herself.
Again, Judge, if the court wants to buy Mr. Nickas's argument that is predicated on a bunch of civil.
Now you're getting like, that's an ass. Like, if you want to buy that, that's you can't. I gotta open the window. It's getting hot as fucking chat. That's kind of a shitty argument to make if you're gonna buy what they're saying. I'd argue if you're gonna rule in favor of the defense, probably a little more professional. She's getting a little personal here.
Cases, with regard to waiver, that's okay. We can just focus on the cases that the defense presented because those are the controlling cases. And that is the controlling statute. We did everything that we were supposed to do. We went above and beyond. And I want the court to understand at the conclusion of evidence, I reminded the grand jury that if there were any documents in Mr. Baldwin's target letter that they wanted to see, I had copies of them right there. And when I said it, I pointed to 3 bankers' boxes that were sitting behind me. They were sitting there in the room and I pointed to them because I had copies of each and every.
Cosmo, yes, they're using Google Zoom or Google Meet because all of Alec Baldwin's attorneys are in New York and the judge is in her chambers and Carrie Morrissey's at her office in New Mexico. Yeah, this isn't uncommon to use Zoom and things like that for hearings like this. This is the beauty of COVID. So, no, this is entirely proper. So, 10K View says, hence my previous question, who runs the grand jury? It's the court. The grand jury is convened by the court, but it's convened by the court at the request of the prosecutor. And the prosecutor is in charge of running it. The judge does not sit there and do anything. When you come into grand jury, the grand jury is convened. You bring everybody in a room. There's a ton of people in there. And then the court, people get picked. There's some basic voir dire. Like, do you know any of these names? Do you know these people? Blah, 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 blah. There's some basic voir dire done. And then you take your jurors you need and everybody else is sent home. After that, the judge has no involvement other than, I don't know, for example, for how it works in New Mexico, but in Ohio, when you're done and you've completed it, once it's completed, you take everything from the grand jury up to that judge who convened it and who's in charge of it. They acknowledge it, they look at it and say, okay, this appears to be error, and they sign off on it. And then those are taken to the clerk, and the clerk starts filing indictments. That's the process. So the prosecutor, the judge is like overall, it's just in charge. But once he convenes the grand jury and the jurors have been picked, he kind of fucks off. Like you heard him say, he's like, if you need me, get a hold of me. I'm only, he's like Charlie Puth. He's only one call away. But in the meantime, the prosecutor's off doing whatever the fuck they want, and the judge has no oversight. So that's why it's her job to handle the presentment to the grand jury. So it's entirely on her. Sorry, my bad. Don't apologize. I'm trying to make sure you understand it. If I came across as an asshole, you could say, hey, Sean, you sounded like a dick when you just said that. That was not my intent. Not my intent at all. Patty says, so they're keeping the COVID remote stuff. How can they justify that? Well, why would they drag Alec Baldwin's attorneys out for like a fucking 2-hour hearing? That's kind of fucked up. This maximizes courtroom efficiency. If you can handle all kinds of shit over the phone or do telephone pre-trials or do video pre-trials, that helps me out. That helps me so very much. Helps the court out. But now I can get more stuff done during the day. I don't spend time driving that I have to. Like, it's been a boon for attorneys getting stuff done. So, no, there's a lot of advantages to it. This allows for people, think about especially for people who are indigent or they have transportation issues, you can do hearings over video. So if you got a client who can't get anywhere, like I take court appointed cases, guys. So like I don't have a car. I can't afford to drive. Like I got to spend a license. Efficient courts are a good thing because that means you benefit from it. Timely and on-time courts are important. So. You sound like a gay-throbbing dick when you said that. Which part? Which part? Fenris is saying, is the Ohio Supreme Court rule about public attended hearings still in effect? I don't think so, and I'm not sure which one you're talking about, but you have the right to attend hearings still. And if the court won't let you in a courtroom, they have to make it available some way for the public to view it if the public is going to come view it. So, anyways, let's hear it go.
Document for all of the grand jurors, and I think there were like 22 grand jurors in the room. So not only did I tell them, knock on the door and let me know if you want to see any, I made very clear to them that they were there and that they would all have copies of them if they needed them. This is not a trial. This is grand jury. They provided an alert letter. We read it. We followed all of the judge's orders. If the court has any questions for me, I'm happy to answer them.
I'm going to let you do your reply.
Ooh.
So,
Go.
Your Honor, just very briefly, and then I'll turn it back over to Mr. Nikas because a couple of the points directly related to his points. But the colloquy with Judge Ellington suggested that he understood the logistic problems. That's what being a prosecutor is like. Sometimes it's not easy. You want to have a case on the last day, you don't get the fast pitch it. There's lots of options, right? One option is to have the witnesses there, one of them there, one exhibit there. Right, there's nothing in the transcript about pointing at some boxes of evidence. There's nothing like that there. And
that's a good point. There's no record.
So what Judge Ellington is saying is, hint, hint, you might want to be careful. I know I'm going to get emotion on this, and this is a runaway case, and there's a lot of zealousy going on. You could also delay the grand jury presentation so that you're not on the last day. There's lots of options to do it. Anybody who's a seasoned prosecutor knows that. And then the other point that I would just make is where Miss Morrissey started, which is, this wasn't nefarious, wicked, evil acts of horror. I never said that it was. I don't think this is some wicked, evil prosecutor or some horrible person. But on that day, in that grand jury, they didn't do what they should have done. It's just that simple. You're not supposed to do that when you're a prosecutor. You're not supposed to conduct yourself that way. And that's not an indictment that this court can hang their hat on.
I have just a few points, Your Honor. Our briefs address anything that the state has argued. Most of what it's argued, in fact, has been waived in any event. But just a few points to illustrate some of the areas where the state has made comments that are not accurate, and ultimately we'll hang our hat on everything else we put in our brief to demonstrate that the rest of it is consistent with these. And so, number one, the state says, we don't cite any criminal cases on waiver. We only cite civil cases. That's not accurate. We cite State versus Vaughn. The standard on waiver is exactly the same for both scenarios. Number two, the state says, we didn't call Detective Hancock to talk about gun safety because she didn't know about gun safety. That's why we stopped her and we actually had somebody else testify. That's not accurate. Ms. Morrissey asked Detective Hancock about what happens when the armor hands the gun off to the actor. And Detective Hancock said she's supposed to do a safety check with the actor, and ultimately that wasn't done.
Uh-oh.
So the testimony of Hancock, even though we just heard from the state, she's not knowledgeable about safety standards, the state elicited that. Number three,
oh, you heard her. She wanted to answer that.
Honor, the Harrar case does not say when a target is giving testimony and the target is saying a certain thing and the state cuts them off, the target, because the target has a right to be there, therefore has created a scenario where an indictment must be dismissed. The outcome of that case had nothing to do with the fact that it was the target testifying. The court made very clear that when a prosecutor cuts somebody off and denies the grand jury information that they've asked for, that period full stop is an interference with the process and denies them what they're entitled to. And if Your Honor looks through the transcript and sees the number of times the state said words like, let me stop you, or I'm going to stop you, or you're going to hear this information from somebody else. It's over 20 times. Day 1, pages 20, 26, 27, 34, 88, 160. I could go on and on and on, Your Honor. This was something that happened. It was pervasive throughout the entirety of the process. And so if you look at the Herrera case and the basis for it, and you look at the cases we cite, we respectfully submit they require dismissal. And the state did not discuss and talk about and analyze these cases. The only reference the state made to any cases was when it said in Judge Ellington's order, where he cited Herrera and quoted Jones, Judge Ellington said such and such. There was no analysis of the case law. There were no cases cited for
send
authorities.
me that. Hold on, wait.
The state didn't address any.
Number one, send me that, Robert, please. No, I want to hear that. Number two, like I said, guys, you know, and here's their agreement. And here's a neat thing. Luke Nikas is agreeing with me. She shouldn't have been cutting people off. What she should have done is said, detective, do you know the safety rules? No, I don't know. I'm not a fucking movie guy. I'm a detective. Okay, cool. And then bring in that person. So the judge drive-bys, Oklahoma Judge Brian Lobel. Okay, thank you.
Any of these issues in its brief. And so, Your Honor, we could go on and on, but Your Honor has questions. That's what's most important to us. And everything else that we've written in our brief, we believe is clear, and we simply refer to them.
All right, thank you. First of all, I want to ask Ms. Morrissey where she's relying in Jones and Herrera on the fact that they have to demonstrate bad faith before they can get into any of these arguments.
Ooh,
Yes, Your Honor. It is.
Oh, that's. Uh-oh.
Hang on.
Judge is starting to. She's like, kind of tell me why that argument's not right. She's like, I think they got a point.
Just one second. Give me just one moment.
Sure, take your time.
Yes, the big city lawyer pretend he's got so many cases he can't hide all the boxes. I guarantee you that guy. That firm they're at is probably like you bill like 2,000 hours a year firm. So I guarantee you he's got a fucking assload of cases. But I'm also thinking he's like, God, maybe look like I'm an attorney. Okay, look. Okay, you know what? Stop. You know what? In his defense, you know why I got those books right there? Do you know why I have those? Do you think I actually use those law books? No. It's a set piece. That's all it is, chat. It's a set piece. So no, I don't think the guy kind of staged it a little bit, but I'm sure he just threw all the shit in the boxes and called it good. Those aren't law books? Yeah, it is. It's Katz and Gianelli on criminal law in Ohio. Yes. Is the gun also a set piece? Well, I mean, it's sitting there because I got a Glock thing there. But yes, I mean, it's an actual gun, though, too. I cuddle them books. Thanks, Brittany. Jesus. All right, getting back to it. You people. I can't read. Yeah, you're right. I can't read. I went to a public school.
Paragraph 13, I believe, Your Honor. And in addition to paragraph 13, I would also rely on 31611A. The sufficiency of the evidence upon which an indictment is returned shall not be subject to review, absent a showing of bad faith on the part of the prosecuting attorney assisting the grand jury.
Okay, so I started off asking counsel to address the two types of errors. One is, which I'm quoting from Herrera, and that's paragraph 12, challenges arising from grand jury proceedings ordinarily fall into two categories. challenges to the quality or sufficiency of the evidence before the grand jury, and structural challenges involving the manner in which the grand jury process has been conducted. If you finish the paragraph 13, it says, in accordance with the statute, our courts will not entertain a target's challenge to the quality or sufficiency of the evidence presented to the grand jury unless the target demonstrates prosecutorial bad faith. And your cite to 31611 also talks about the sufficiency of the evidence upon which an indictment is returned shall not be subject to review absent a showing of bad faith. That doesn't include structural. And Mr. Nikas addressed structural right after the waiver. And so I think that the fact that you're arguing that he has to show bad faith is incorrect on other than the sufficiency of the evidence. So I don't think that that was properly addressed by you. Now I'm going to ask you.
Let me translate. Uh-oh. Uh-oh. That's not good, chat. That's not good. Not good for Gary. Yes, ruh-roh, Raggy. Yeah. Uh-oh. Uh-oh. Doesn't mean she's boned. But she's like, you did not, you kind of missed the point. Does Baldwin go free now? Not yet. Let's see. We got to listen.
Some questions, and I'm going to ask you questions because you were the one doing the grand jury. So I may ask Mr. Baldwin's counsel, but I'm primarily focused on what occurred at the grand jury. So one of my first questions.
Real quick, because she's an officer of the court, she's always presumed to be under oath. She is not going to be sworn in. The court's asking questions to gather evidence and to make findings of fact, and findings of law. She's always under oath, so she's not sworn in because she's an officer of the court. Yeah, she got called out subtly. Yes. Garrett Pace for 11 months. Been a member. Thank you. Real lawyers have Warhammer books. It's like real lawyers actually know the Warhammer lore. Also, real lawyers have guns they paint and use. So here we go, chat.
Is and I'll try to stay. Well, let's go to the information about the lack of advisement about the target. The target, you saying that reading the target alert letter went above and beyond what you were required to do. And you gave some information about at the very end. You even reminded them of the boxes. And I'm just wondering why you wouldn't have reminded them of the witnesses as well at that time.
Ooh, uh-oh. Uh-oh.
Well, the reason that I wouldn't have reminded them of the witnesses is because they had the target's alert letter in their hands the entire time. I know for a fact that they reviewed it, and you can see that from the transcript because they were actually asking about typos in it. So I understood that they had reviewed it. I understood from the hearing that we had on January the 11th that the clerk of the grand jury was providing them with a refreshed instruction that they had the power to request any of these witnesses. So it was my understanding from the hearing that we had on January 11th that they were being provided a refreshed instruction in that regard.
Okay, thank you. When you talk about, as we know, Judge Ellington said, make the witnesses readily available. And in your response, you said that you would have made them readily available had the grand jurors asked, and you said if they couldn't come in person, I'd ask the grand jury judge for permission to have them appear by video testimony. But then you also said, or I would have given them interviews of that, pretrial interviews or investigative interviews. How can a grand juror ask questions from a transcript?
I agree with you, Your Honor, and this was one of the things that was discussed during the hearing with Judge Ellington.
Chat, you need to hear that again.
You would have made them readily available had the grand jurors asked, and you said if they couldn't come in person, I'd ask the grand jury judge for permission to have them appear by video testimony. But then you also said, or I would have given them interviews of that, pretrial interviews or investigative interviews. How can a grand juror?
None of those exist anyway, because you didn't interview these people. I would have brought that point up if I was the judge. You said you would have done it, but they don't exist to start with.
Ask questions from a transcript.
I agree with you, Your Honor, and this was one of the things that was discussed during the hearing with Judge Ellington.
This is, guys, I've been in that. Yeah, felted. She just got fucking felted. That said, though, I've been in that situation when you're on your back foot and you got to figure something out. Yeah, she get felted. She getting dizzled, as the kids used to say. Where's my roommate in college said Pizza Hut pizzoned.
And I believe it was the same hearing on January 11th, was the fact that some of the witness testimony that Mr. Nickus wanted to present was directly from the interviews. So for example, what Mr. Nickus would do, and you can see in his notice and his alert letter, he provided to the court these exhibits that were summations of the police report. So for example, he provided the court with a copy of Detective Hancock's supplemental report that described her interview of Jensen Ackles. And so I had a discussion with the court about if what the defense is asking for, and they certainly were not asking for this for every single witness. So I didn't think that this was going to fly with every single witness. But if what they were asking for was this witness's testimony as it was given to Detective Hancock or Detective Cano, and we had those audio recordings, then we don't need to bring that person from California to have them talk about that in front of the grand jury. We discussed that with Judge Ellington, and he indicated, yes, that would be a possibility. So I do agree with the court that when presenting the testimony that way, if the grand jury had questions, they would be having to pose those questions to Detective Hancock as the person who did the interview. And I want the court to know that I actually spoke to other prosecutors, primarily in the 2nd Judicial District, to ask if they had ever presented witness testimony over video, Zoom or Google Meets, and they indicated that they do it all the time. So I had actually taken steps to ensure that I had a leg to stand on with regard to having witnesses testify via video, understanding grand jury secrecy, that one of the things that we would have to do if we did that, if Judge Ellington approved it, would have been having the witness under oath testify that they were alone and that they weren't recording. And
notice she tried to. Here's the thing: she just tried to couch that up, and I made sure it was okay. She didn't go to. She said, had the judge granted it. She didn't go to the judge before and say, "Hey, judge, here's what I want to do. Is that okay?" Nope. She didn't do that. She didn't do that. She didn't go to the judge ahead of time. She said, had the judge granted it. So she wasn't really prepared. She's like, okay, well, here's my plan, but she hadn't even really set the plan up. She had basically drawn out her plan, but she hadn't even enacted it. This was sloppy, guys. This is really sloppy. Holy cow, yeah. Stop Moss B for $5 is Happy Pizza Day. Yes. Yes, Happy Pizza Day, chat. Thank you for the super chat. I appreciate the support. So no, 10K, you 100% are reading that right. The judge did not grant the change. She planned to do it, but she never got that far. She's like, well, if I need to, I'll worry about it when I get to it. Exactly what you're exactly reading it the right way.
Etc. To try to ensure grand jury secrecy. So I was trying to come up with ways of presenting some of the testimony. Now, with regard to some of the witnesses, though, I was not at all opposed to having them there in person. The problem with the situation was we only had a week from January the 11th. We didn't know how Judge Ellington was going to rule.
Why didn't you plan ahead then?
So on January the 11th, we get the ruling. And then at that point in time, I'm trying to figure out what to do with these out-of-state witnesses. It's true, I didn't have Sarah Zachary sitting in the hallway, but I could get her there, and I knew that I could get her there because I had talked to her attorneys on the phone about grand jury. So for the local witnesses, the witnesses that were local, that the defendant wanted the state to make available, I absolutely was intending to have them there in person. It was the out-of-state witnesses that I was trying to figure out how I could juggle those. So I was hoping that if the testimony was requested, we would be able to do it either from video interviews, understanding, Your Honor, that there may be an issue with regard to grand jury questions, or just having them present by video, which my understanding is in the second is routine. So that was my plan at the time.
I'm curious as to that you didn't reach out to any of these witnesses other than what you just said, Sarah Zachary, to just sort of touch base with them, see if they were available even by video.
I'm not I actually don't agree that I didn't reach out to them to see if they were available.
Uh-oh, chat. Oh, no.
I recall, I believe I had a conversation with Mr. Souza.
Uh-oh.
I did not have a conversation with Mr. Halls, but that's because he was represented by counsel. And his attorney was historically very difficult to get a hold of. So I was going to have to try to manage that as best I could through Judge Ellington if the grand jury wanted to hear from Dave Halls. I don't think that it was just Sarah Zachary. I'd have to go back and look at all of the witnesses.
Oh no, chat. Oh no. Oh no. Oh no. We've gone from uh-oh to oh no. This is not good. Yeah. Carrie Safa, Carrie Safa. Yeah, this is this is not good, chat. She is not scoring points. She's losing. She's starting to drown.
That the defense asked that we present, because I did make phone calls to kind of let people know that this may be an issue that would be coming up. I specifically spoke to Mr. Winger with regard to Ms. Zachary. Do you want me to go through the witnesses? I'll have to pull up their alert letter. I can go through each and every witness.
Well, you never responded that you did. That they said you didn't, and you didn't respond that you did. And there's 7 of them.
Sure.
I'm just asking. I mean, if you're saying that you did.
You need to root for Kerry, otherwise no Baldwin trial coverage. I understand, but god damn! God damn, Kerry is getting fucking slaughtered right now. This is not good. Basically, she didn't fucking do anything. I had a plan. Did you enact any of that plan? No.
I mean, I'm just curious as to, you're saying, well, I was trying to coordinate this and, you know, I knew that Zachary I'd get in and Hall's attorney's pretty difficult to get a hold of. Then I'm curious as to, even by video, how you would have how you needed to. Common sense tells me you should have reached out ahead of time. That's all.
Oh, I agree with you. And I'm telling you that I think with regard to Mr. Halls, I reached out to these people. But for this, let me look at specifically all of the witnesses and let me address the court's inquiry here. I have so many documents in front of me. I'm trying to find
Take your time.
I'm trying to find their alert letter. I had it in front of me.
Oh. Oof.
Here, I'm getting there.
Danny say defense attorneys love trying the prosecutor. Hey, if they fucked up, why not? Well, there's structural error in that. Looks like bad faith on top of it, Danny. That's what I would argue. Ooh.
Okay, witness number one, Mr. Souza. Mr. Souza was extremely cooperative with me. He made himself available anytime I wanted to speak with him. I believe that I would have had absolutely no issue having Mr. Souza appear via video. The next witness number two, Mr. Halls, I've explained that. He's always difficult because we have to go through his attorney and she can sometimes be somewhat non-responsive. Ms. Zachary, witness number three, I've addressed that. Witness number four, Ryan Smith. I did not reach out to Ryan Smith. He, as a producer for Rust Productions, I believe that technically he is currently represented by Ryan Villa. Ryan Villa has been extremely cooperative with me, and I expected that if the grand jury wanted to hear from Ryan Smith, I would have been able to present his testimony through the cooperation of Mr. Villa. Detective Hancock was there. Of course, the grand jury was free to ask her any questions that they wanted that she could have had the answers to. Witness number six, Joel Cano, absolutely. He's with the sheriff's department. I could have had him there within 10 minutes.
Okay, but that's not...
Mr. Schilling, I did not reach out to Mr. Schilling, but I absolutely had full confidence that if the grand jury wanted to hear from Mr. Schilling, although I
don't know
his testimony, I can't imagine would have been highly relevant to them.
You don't know
I would have been able to get Mr. Schilling there. I think Mr. Schilling lives in Santa Fe.
He would
have been very, very easy for me to contact and have him there. He's retired, and he is generally available.
See, if I was the judge, I would just
say, and I want the court to know that, you know, one of the reasons that we...
Miss Morrissey, just say the answer is, I don't know if those people would have been available. I don't know.
read the target's alert letter at the beginning of the grand jury is so that if they say, okay, we've met and we've conferred, and we want to hear from these 3 witnesses, or we want to hear from all 7, then I can tell my investigator, while I'm presenting the witnesses that we have here, you got to go get these other guys. You got to call Mr. Winger and you got to tell him that Sarah Zachary needs to be here. And you need to go knock on Mr. Schilling's door if he doesn't answer his phone. So we would have had time to do those things. We knew that this grand jury was going to take quite a long time. I know that the defense has continued to argue that this was something that we rushed through. As this court knows, it's almost unheard of to have a 1.5 day long grand jury proceeding. We didn't rush through anything. We spent a long time. We had every single grand juror come back the following day. In terms of, let's say, worst case scenario, the grand jury wants to hear from a witness that I can't get there. So I had a specific conversation with Judge Ellington. If that worst case scenario arises, what do we do? Do we ask the grand jury as a group to agree to come back?
Yes.
At a later date? And he indicated that was a possibility. Now, the other possibility is that if the grand jury wants to hear from a target's witness, and for some reason we can't get them there, and this didn't happen, we can, if we choose to, start the process over. There's no way that we would have, if we had a grand jury that's...
You know why it didn't happen? Because you didn't ask and prepare for those witnesses to be there. Well, it didn't happen because they weren't there. And you didn't make sure they could be there. You were going to worry about it if it happened.
Said, I want to hear from Dave Halls, and I can't get Dave Halls there for some reason. I'm not going to continue with this grand jury proceeding and just have them indict him and come to the court and say, I couldn't get a hold of Dave Halls. That's not how this works. We would have just had to have dismissed it, and we would have had to issue a new target notice and start over. And at that point in time, we would have had a much better idea about what the court's ruling was going to be. We didn't know the court's ruling until January 11th, but if we had to dismiss it and start over, which we absolutely were contemplating could be a possibility, we were willing to do that. We were never going to have a grand jury issue a ruling if they wanted to hear from a defense witness and we couldn't get that person there. Absolutely not.
Okay, I have one more question on with respect to the target letter. So as an aide to the grand jury, and I remember listening to the transcript, and you said, after you read the target letter, you said, we have witnesses available now, and you emphasized in your tone now. And then you stopped and told them, go ahead and read it among yourselves and things. Why would you not just at that time, you're telling me that you, in your response, you said it's not your duty, all you have to do is alert them. And then I asked you today and you're saying, well, they were told to, the jurors, Judge Ellington instructed the jurors to get another copy of that, the duty, what's read to them about their duties. And then, and so that, I think that's, I don't want to misstate, but I think that's the sum total. So as an aide to the grand jury, I'm just curious as to when they were seeing typos, did you not feel as an aide that you might let them know that you could get them there? That's why I asked you about the boxes at the end, because you went to the boxes at the end. You said, we've got the boxes here.
Yes. Yep. The judge is asking the questions you're all asking. Well, you kind of fucked this up, didn't you? Yes. She did.
But you didn't mention the witnesses. And so I'm just curious as an aide to the grand jury, why you just didn't, what would have been what was the motivation, or what would have been the harm in just not saying, and you know what, I can get him here if you need him, or something to that effect. Just make them a little more schooled in what they were. Do you stand by that it's not your duty, basically?
I stand by that it's not my duty because the law and the case law doesn't require me to do it, but I don't want the court to feel like there were things that we were unwilling to do because we were kind of engaging in some kind of gamesmanship, like if the law doesn't require me to do it, I'm not going to do it. My honest belief at the time was the judge has provided them today with the refreshed instructions about their duties. So I had no reason at that point in time to believe that they were confused about whether or not they could ask to hear from any of these witnesses. If Judge Ellington hadn't specifically asked,
I don't know about that.
That instruction be provided to the grand jurors again, because it was provided to them in orientation and he had them refreshed, possibly I would have handled it differently. But because he did that, I didn't believe that it was necessary.
Do you know whether they got that? You said that morning. Do you know whether they got that?
I was assuming that when Judge Ellington, and that was actually part of the audio that I wanted to play.
The answer is no, you don't know. Oh, no, chat, no. Yeah, just say I didn't tell him about the witnesses. And she didn't tell him about them because they weren't there.
When Judge Ellington instructed, I think he said Ms. Hurtado, I think that's Ruth, when he instructed her to provide those, I had every reason to believe that she was going to do that. She was on the call. So when we had the hearing on January the 11th, there were several court employees that were on the video hearing, and she was one of them. So the court specifically told her during the hearing, the court didn't say, this is what I'm gonna do. He told her during the hearing, this is what you need to do. I assumed that she would have followed his instructions. I had no reason to believe that she wouldn't have done that.
Okay, I am aware of that. I did listen to that. I want to get into what was raised about asking the witnesses questions. In the beginning, you tell the grand jurors that this is how we're gonna do it. I'm gonna ask questions of the witnesses, and then you can ask questions, and I'm gonna interrupt and say you can't answer that question if I consider it to be not a lawful question, and I may have them rephrase the question. And so, got my notes here. So, having gone through the transcripts, I'm in Herrera and talking about how Herrera says, and so you're honing in on the target. You seem to be honing in on the target in Herrera.
Yeah, Michael. Yeah, she's a private attorney. We've already talked about this. She's not the DA, nor is she a regular prosecutor. Yes. But dude, she's an experienced criminal defense attorney. She knows these rules inside and out. So the idea that she doesn't know all this is kind of shit. Like, she doesn't have the excuse. I know you've put this up here a couple times. I thought I highlighted it. This isn't like she doesn't know what she's doing. So she just got lazy.
In Herrera, it says, by preventing the target from answering a direct relevant question from a grand juror, the prosecuting attorney interfered with the grand jury's statutory duty to make an independent inquiry into the evidence supporting a determination of probable cause. So I think you've said two things, and please correct me if I'm if I'm wrong, because I've been, taking notes, but I'm not a transcriber. So, you talked about that it was the target in that case, and you seem to make a distinction between the appellate court saying that that they interfered because they wouldn't let the target answer the question. But then you also said that that you came well within Herrera, and so that you didn't interfere with their ability to ask questions. So I just need clarification. Are you interpreting Herrera to mean that the appellate court based it on the fact that the target was interrupted from answering the question versus another witness of the state?
Judge, the only thing that I can say is when we're looking at cases and we're distinguishing cases, looking at the facts of the case, that's what we look at to see if it's distinguishable. I don't know what the Court of Appeals would do if it wasn't the target. What I can tell you is that I think that depending on the substance of the testimony that's coming out, the Court of Appeals may handle it differently because the target has a right to testify. So I think that is a difference. The target has a legal right to testify. The target is the only person who has a legal right to testify before the grand jury. So I think it's entirely possible that the higher courts...
Now remember, while he does have a legal right to testify, the grand jury can't demand him testify because he has the right to plead the fifth. So he can testify, but they can't force him to show up.
Would treat that somewhat differently depending on what the substance of the testimony was. And again, it was my intention not to prevent the grand jury from getting the information. I just wanted the grand jury to get accurate information. And I had concerns that a police detective wasn't going to give accurate information about safety protocols for guns on movie sets because she's never worked on one. And I certainly would submit to the court that that's not bad faith. That's me trying to make sure that the grand jury doesn't get confused by getting inaccurate information.
Okay, so it did involve the target, but it said it's not the target. I don't think Herrera was focusing on the target's right. I think Herrera was focusing on the grand jury's ability to ask questions without interference. It says, by preventing so-and-so from answering a direct, relevant question from a grand juror, the prosecuting attorney interfered with the grand jury's statutory duty to make an independent inquiry into it. So I noticed that Corporal Hancock was able to answer several questions, and they were about the firearm. They were about she was able to ask questions about sorry.
You guys remember the judge has the transcript already. So she's gone through the grand jury notes. She's trying to find her notes. Give her a second. Oh, this is not good.
Okay. So they're asking questions like, they were talking about live rounds. They were all in different places. One was in the actual gun that was used, and Hancock says yes. There wasn't another one in the gun. Corporal Hancock answers that. And then they're talking about were you able to get all of them back? Yes. The gun was already unloaded when we got there. And then you know they're asking her questions, and you say, "Can I try to help?" And you go along. But then the first time you interrupt a juror is with Corporal Hancock is when one of the jurors asks if the bottom line is the response. And it's a very direct question. And so you're going to tell me that she could not have answered this. And so the bottom line is the responsibility of making sure these guns, these bullets are not live, are up to what? David Halls and Hannah. And you did not let her answer that question. You said, we are going to have another witness address those issues for you.
Ooh.
We have an expert who works on movie sets, and he's going to answer those questions for you if that's okay. And so my question is, she was the lead investigator on the case. Her testimony shows that she could have answered that question, and you would not let the grand juror get the question from Ms. Hancock. Why is that not what Herrera says you can't do?
Oh no. Oh no. Oh no. Oh no. What's the remedy here? Dismissal with prejudice might be the only remedy. I mean, you can't re-indict. Uh-oh. Uh-oh. Carrie better start digging a foxhole. She's about to get shelled. She's getting fucking shelled right now. Notice like Alec Baldwin's attorneys, you haven't fucking heard a word from them in like 45 minutes. They are just sitting there. They got their binoculars out. Hold on. Yes, my defense class. 1941 to 42 manufacture. They're just sitting there. They got their glasses up. They got their binoculars out, their field glass out, and they're just like, wow, she's getting fucking wrecked. And they're just watching artillery round just boom right on top of Carrie. So, yeah, this is yeah. Once again, this is another like, oh no. I've had the opportunity like where you're getting ready for like a pretrial of your own, and there's a hearing before you, and you're just watching somebody get fucking murdered, and you're just like, oh no. You don't even know what it's about. You're just like, oh no, like, and you feel bad for whatever side's getting killed because you're just like, fuck. You're just like, oh boy. Yeah, she's in trouble. Here we go.
So what Herrera, in my reading of Herrera and the way that it would apply to this case, is the grand jury was prevented from getting the answers to the questions. I did not prevent the grand jury from getting the answers to the questions. I made sure that the grand jury got the answers to their questions from the witness with the most experience. And I want to back up because, Judge, what you indicated in terms of all of the questions that Detective Hancock did answer, those all pertain to her criminal investigation. Where the guns were, where the bullets were, did they recover all of them? Those all pertain to her criminal investigation.
Mm-hmm.
My concern was that Detective Hancock didn't understand, or perhaps didn't recall what she had been told because so much time had passed since the time that she...
You don't know that because you didn't let her get asked the question. Well, I didn't know what she was going to know. That's why you let her ask the question, and she then gets to say, Detective Ducklips. She'd go like this. She can say, I don't know. I forget who I talked to, but I talked to some movie person. If the witness doesn't know, you let the witness answer the question. Brittany says, get the dustpan. Well, I was on I remember as a young, I think I forget how old I was. I don't know. It's probably like 15 years ago. I was on an internet forum and a message board, and there was going to be these guys were having an argument. And the guy who was, one of the guys arguing was an old timer. He's like, bring a fucking wagon and a glass of milk. You're going to fucking need it. Gary, you hope you brought your radio flyer and a glass of milk because you're getting fucked up. But yeah, this is not good.
Did her interviews, the very specific way that the safety protocol takes place between the armorer and the assistant director. So I presented that information to the grand jury. I had their question answered, and my expert absolutely said, the safety check is a safety check that takes place between the armorer and the assistant director. He did not say that it took place with the actor in terms of that initial safety check. So I think that there is a very stark difference in what happened in Herrera and what happened in this case, especially when we're talking about bad faith, because my intention was to get them the most accurate and reliable information. And having a police detective who's never worked on a movie set try to give some kind of a detailed explanation about the exact manner in which this safety inspection is supposed.
That's not true, because we heard her say that. She used to be an animal wrangler. She's one of the detectives that said she was an animal wrangler when she was talking to Hannah. So that's not fucking true at all. She has movie experience. But oh my God. Look at her fucking face. Look at her fucking face. That's panic, chat. She's panicking. She knows she just took a hit and she's on fire. Yes. That's not true. This is what she's going to break out to next. Who was her expert? Her expert would have been Brian Carpenter, the movie guy.
To happen was concerning to me, and I also want the court to know that the reason that this death occurred is because the safety protocols were not followed. So during her investigation, what Detective Hancock learned was the way not to do things. Detective Hancock never talked to, I don't think Hancock ever interviewed any of the crew members and asked the experienced crew members how the safety protocols were supposed to work in a way that wasn't this distorted way that happened on this movie set.
In her investigation?
So it wasn't necessarily that I didn't want her to give the information. In fact, I can tell you it wasn't at all that I didn't want her to give the information to the grand jury. Detective Hancock got a bunch of information from people about the way not to do things. That's the reason that Halyna Hutchins died. So I actually didn't believe that she fully understood the way that things are supposed to happen, because the sheriff's department doesn't go hire an expert and get a teaching lesson in how these things are actually supposed to happen. She got her information about how things are supposed to happen from the three people who didn't follow the rules, that being Hannah Gutierrez, Dave Halls, and Mr. Baldwin. She didn't conduct any of the other interviews with the crew who would have been able to tell her, had they been asked, this is the way this is supposed to happen. So I had a good faith basis to believe that she only understood how it's not supposed.
Why wouldn't your detective had asked them something went wrong? Why wouldn't your detective be asking people, hey guys, how is this supposed to have actually gone? Minus the dead body. Like, how would you have been able to prevent that? That makes no damn sense at all. That makes no damn sense at all. No, Charlie, if this happens again, it's a dismissal of the case. That's it. You're done. Game over. You can't keep going back to the well. So no, she should be done. She should be done if she's fucked this up. Sometimes you have to punish the state, and that's how you punish the state. They won't fuck this. She won't fuck this up again. Her failure will be seen as a monument to others to avoid the issue or avoid that problem. But seriously, though, how is she supposed to know? She's supposed to ask. Why wouldn't she know? What kind of detective is she?
Supposed to happen and didn't understand how it's actually supposed to happen.
Well, to that point, a couple of things. Well, first of all, Corporal Hancock interviewed Jason Ackles. And in that interview, he had different information about safety protocols on movie sets, which would that have been exculpatory information?
I'd have to review it. Do you want me to review it now? I'm happy to.
Okay, so here's, I'm just saying she did have some information, I think, but in any event, when you're saying, so you're saying she was not the best witness to answer that question, or she wasn't capable of answering that question given her limited, she didn't know what the best practices were. Is that correct?
That's correct.
Okay, well, so,
Why doesn't?
but in other ones where you go, this is, I think this is Mr. Rice. Or is it, yeah, I think it's Mr. Rice. And you say on Exhibit 20, page 86, and it says, looking back at the alert letter, there's a notation that Sarah Zachary, the prop master for the film, was also the supervisor for Hannah Reed. But nobody's talking about her playing this. So you know where I'm going. Go ahead. And you say, you interrupt her and you say, I don't know if he's familiar enough with that, with the relationship between the prop master and the armorer to answer that question. But we have a witness sitting out there who may be able to answer it. If we can bring back Mr. Looper back, if you want us to. And the juror says, my biggest part of the question is, she was also responsible for procuring firearms and ammunition for a third party, not just Hannah. And then you said, understood, let me back up for a moment. And instead of asking him about procuring firearms, you say, do you have any information about the firearms training or firearm familiarity with Sarah Zachary? And you do that, but then later on, even though you say, this is not he's not familiar, I don't think he's familiar enough with this, you do end up asking him after, maybe 3 minutes later, do you know about whether she was responsible for procuring? And he answered it. And so my point is that you decided that she wasn't the best one. You said, we've got another witness to do this. But then we have an example here where you're saying, I don't think he's familiar enough with it, but then you let him answer the question, which you just asked the question of the juror. I can read that into the record if you want.
I just want to follow where you are so that I can
respond. So it's page 86. It's page 86 of Exhibit 19, and it says.
Hang on, just a second. Let me catch up.
20. It's 20.
Page 20.
No, it's Exhibit 20.
Okay, I have Exhibit 20 in front of me.
Okay, and it says on page 86, you say, she's asking a question, and you say,
This is,
But, okay, so you say I don't think he's familiar enough. You say we can bring in somebody else. You ask her a different question from procuring. You ask about training, but then later on, you finally get to it and you say, on page 87, line 18, and in terms of Ms. Zachary, what is your understanding of where she procured the guns? So my point is that I don't understand how you can say, there was a better witness at this, so I just said there's a better witness with Hancock. And then with Rice, you say, I don't think he's familiar with it. But then you ask the question anyway. I don't understand why the grand juror couldn't ask Ms. Hancock the question and tell the grand juror herself that she couldn't answer it. Why were you telling the grand juror that she couldn't answer it?
so first of all, in terms of what you're speaking about with regard to Mr. Rice, I would need just a moment to.
You know what that was right there, chat? First of all, this flailing. Oh my God! Oh! That's what that was. That's what that was. If she fucks up, is this over? Pretty much. Fucking much, chat. Pretty much. This bitch is gonna fuck me out of a trial. This, I am disappointed that she did this as a prosecutor, but I'm also disappointed. You know how many fucking trial? There's a trial we could cover. Memberships and super chats. Bitch, you're stealing money out of my mouth. You're taking money out of my pocket. Come on, Carrie. Yeah, my views, and I gotta earn. If I don't earn, 2.0 is gonna kick my ass. If I don't earn, they're probably gonna indict me. Shit. Yes, you had one job. I'm glad I didn't go out and buy that revolver now. So I was thinking about it. So it wouldn't be a tax write-off anymore. Because it didn't happen.
Review that.
Okay.
If that's okay. So, because I think that's going to be pertinent to my answer. So I'm
Absolutely.
I'm on 86, and in fact, Judge, I already have that portion highlighted.
I've been in her shoes before. That's the, well, fuck, look. Trust me, I've been there, chat.
Okay, so let me kind of describe what was happening here, at least in my mind. So the initial question on 86 that is asked by the juror, the grand juror says, looking back at the alert letter, there's a notation that Sarah Zachary, the prop master for the film, was also the supervisor for Hannah Reed, but nobody's talking about her play in this. So you know where I'm going, go ahead. And I don't believe I interrupted her. And I said, I don't know if he's familiar enough with that, with the relationship between the prop master and the armorer to answer that question. And the issue that's going on in my mind is is Mr. Rice, who has also never worked on a movie set, familiar with whether or not the prop master is the supervisor of the armorer when it comes to the armorer's responsibility for gun safety. So what I'm thinking in my mind at that point in time is my investigator can't answer that because he's never worked on a movie set. Then things change because the grand juror says, she clarifies her question. My biggest part of the question, if she was also responsible for procuring firearms and ammunition from a third party, when she clarified her question in that regard about where the firearms and the ammunition are coming from, and at this point, I understand she's not asking about the relationship as it pertains to who can tell the armorer what the armorer can and cannot do with guns. She clarifies the question. When she clarifies it, I realize he can answer it. He actually does know the answer to that. He knows that Sarah Zachary got the guns and she got some other ammunition from Seth Kinney. So at that point in time, I say, oh, okay, now that you've clarified your question, I mean, I didn't say it, but that's what's going on in my mind. He can go ahead and answer. So I let him go ahead and answer when she clarified it, and I understood that he did have the knowledge and experience to answer that specific question. Judge, I have to tell you, if I asked Detective Hancock right now to give us a detailed explanation of the way that safety protocols on a movie set are supposed to work, not the way they're not supposed to work, I don't believe I could get a reliable answer out of her.
Oh, I think she can tell
and
you.
while I understand the court's concerns, I want the court to understand that all I was trying to do was get the most accurate information before the grand jury. And everything that Mr. Carpenter said is absolutely accurate about the way that safety protocols on movie sets are supposed to work.
Thank you. I appreciate that. I just have one more question. So, the rule on grand jury proceedings 5-302.2, it talks about instructions to the grand jury. And of course, elements and defenses is one, but the second requirement is the prosecuting attorney shall provide the grand jury with other instructions that are necessary to the fair consideration by the grand jury of the issues presented. And because it seems to me that Mr. Carpenter was provided opinion testimony, which is true. An expert can rely on that. And I know that they weren't put in as experts because it's not a trial, but you're basically indicating that you relied on him for this kind of testimony. You've got Mr. Haig in there. I'm wondering why you didn't provide that instruction to the jury so they could the credibility instruction on witness credibility or opinion testimony instructions.
It didn't occur to me. It didn't occur to me to provide that. And the defense understood the kind of testimony that we were going to elicit.
Honey, that's saying good luck.
It absolutely did not occur to me to give the credibility instruction. It didn't occur to me until this moment, Your Honor.
Okay. Those are all the questions I have, and thank you for being patient with me and answering them.
If you would permit me, Judge, because I have this morning had to deal with Mr. Spiro and Mr. Nickus, would you give
Total prosecutor death. Oh, damn. That's not good. And we got to read a couple of super chats here, chattel, real quick. Janet Morgan for $10 says, taking money from Clyde's bull chew toys. Yes. Carrie, you are affecting Clyde's ability to chew on bull penises. I hope you're happy with yourself, ma'am. Yes, J-Rock says, I'll never financially recover from this. I'm going to have to sell Clyde. I'm going to have to pay Clyde as a panda. It's like the Chinese guys were doing. I'll have to paint him black and white. I think he's a panda baby. And then Darcy for $20. Thank you, Darcy. Coming up big tonight, saying Phil Foss has a great clip on Twitter from tonight. We'll check that out before we end. But let's finish strong here, chat.
Give me 60 seconds to confer with my co-counsel. I'm not going to have her address
Yes,
the court.
absolutely. Yes,
Let me confer. Thank you.
absolutely. Yes.
Do. What? They're just going, ah! They're fighting over who gets in a lifeboat. It's gonna be like The Simpsons. You just hear like, and like, and the car takes off in the distance. Carrie's just bailing out. Hear her jump out the window. Glass goes, and she's like, ah! And she jumps away. Been a little more than a minute. Carrie's already halfway to the fucking desert. Just a big trail of dust from her office.
Anything else, Ms. Morrissey?
Yeah. So I want to make clear.
Wow, it got really
that
quiet.
What we're arguing right now in terms of
Got super quiet. What the
witness testimony, this goes to the sufficiency of the evidence. I believe though that their argument.
Okay, so you want to answer it as sufficiency of the evidence? Because Herrera was structural.
But I believe Herrera was structural because it was dealing with a jury instruction. And I believe that's proper. So in terms of when we're dealing with jury instructions, that is a structural defect. So
According to
that
who?
comes in under subsection B of the statute. In
don't think you
terms of
truly get to decide
sufficiency
that,
of the
Carrie.
evidence, which is what we're talking about right now, this requires a showing of bad faith. So I agree with you that Herrera was talking about a structural defect, but that's because it went directly to a jury instruction. So in terms of witness testimony and sufficiency of the evidence, they have to demonstrate bad faith. And I think that this is clarified in State v. Yaw, that specifically indicates
Don't cry.
that challenges pursuant to 316-11B, 316-11B requires a showing of bad faith. And I'm looking at paragraph 8 of State versus Yaw.
Okay, anything else? Oh,
No,
sorry.
Your Honor.
Well,
No, that's
yeah, okay. Well, I think it's,
Your Honor, if I could just 60 last seconds on just some quick comments that just the things that come up. I know the court's been patient and I
okay.
appreciate it. Yeah, I just wanted to just very quickly, Ms. Morrissey started by saying, we had this plan that if this didn't all work out, we'd just dismiss the case and start over, right? If this whole, there's obviously, this is the problem with the waiver issues. There's no contemporaneous records that was actually what was going on. And you're right, it's not that big of a deal. The court can dismiss this. If she thinks she should give this a third try, she could. But I just found that to be a remarkable
I would demand.
comment. And of course, we've had the opportunity to.
I'm surprised that he's actually. You're gonna concede that? No, dude. It's a second chance. Like, it's done. I can't believe he's letting them redo this. I that actually fucks him. That hurts. That hurts. That hurts. Why would you force, like, like, Alex, like, I know you're a good guy at this, man, but like, homie, why would you even, I would never even utter the fact she gets a third shot. No, it's 2 and done. She shouldn't get another shot. She shouldn't get another shot. I don't know, I don't like, I get it. He works at a big fancy law firm. He's done all kinds of shit. I'll defer to him, but buddy, why would you even fucking give her like that much room to wiggle? Because now you've given the judge an out. Now you've given the judge an out where she could say, I'm not letting Alec Baldwin walk without a trial. But fine, here. You know what?
Talk to the
There. How about that? Sean, he's doing this for you, Sean. I know. Alex Spiro, if you win, if you guys lose this, and that's the reasoning why, I'm going to send you a bottle of champagne. It might be like $2 champagne, but it's still champagne. I'll have a note on it. Thank you. Saving the trial stream. Oh my gosh. This is not. I'd be going for the kill. I'd be going for the kill shot. No, judge, it's done. Dead.
witnesses and the lawyers, some of whom Ms. Morrissey was kind of recreating as she was live being questioned by you, Your Honor. And even just now, they're confirming she never contacted them. Mr. Hall's lawyer confirms never was contacted about the grand jury. Mr. Sousa's lawyer previously commented not contacted. In addition, the court should know we served a discovery request. We said any communications with any witnesses, okay? Show me one email, one internal, anything. Saying, hey, we've got a grand jury in a week. The way this is supposed to work is the grand jury's in a week. There's all these witnesses that could come. You hit them with a subpoena, they come to the grand jury, or you have them on standby and you talk to them. This isn't how you're supposed to do it, period. And this is why the rest of it happens, right? And the grand jurors, they don't know what's going on. They're looking at typos. They call it a warrant letter. And the fact that there may have been a repeating of the very generic instructions that Judge Ellington was right to provide them, Judge Ellington saw it. He said, we're in the last day. They've never seen an alert letter. You have the obligation. You have the obligation. This is a homicide case. And by the way, in Willoughby, the indictment was dismissed even though the grand jurors were presented with the generic sort of instructions. And so the final thing that I will just simply say is, it was very interesting.
What am I doing? What am I doing here? Why is this guy
Ms. Morrissey, please don't interrupt him. Okay. If you want to respond, I'll give you three minutes. Go ahead. Let him finish.
So, and then this was frankly the most remarkable part. The idea that it was going to be video testimony. This is what she purports to be her idea at the time, or read the police reports. You see, because she has to answer Your Honor's question. She can't answer it, so there's no good answer, right? So she says, read the police reports, which is, of course, hearsay. It's the lead detective, the lead investigator, testifying through a document as the hearsay, right? She has no choice, but she's backed into a corner. She has to say that. Then when she has the answer for the next issue, she says, no. Hancock and Rice, they can't be asked to testify about things that they learned from other people. I mean, the story doesn't work, doesn't check out, doesn't pass the laugh test. And so, of course, she cuts them off. And if you look at all the cuttings off, the 20 times, don't answer that one. No, not that one, not that one. It's always in one direction. She doesn't cut off anybody saying, I don't like Alec Baldwin. That's for sure. It's always in one direction. This is a homicide case. Prosecutors are required to do better than this. This indictment should be dismissed.
All right. And you may close, Ms. Morrissey.
I don't recall representing to this court that I reached out to Mr. Hall's attorney. I did not represent that to the court today. I specifically indicated that there was always a problem because he was represented by an attorney that was non-responsive. Mr. Sousa isn't represented by a lawyer. I have no idea what Mr. Spiro is talking about. Everything that he's saying to you right now is a complete misrepresentation about what has happened. And that's what these people do. So hearsay is admissible in grand jury. Hancock and Rice.
Oh, shit. Oh! Oh! God damn! Here's her long time turned on her. He made her a crack in a motion hearing. Yup. He will fuck. He didn't. It's not even made her crack in a motion hearing. He fucking got her goat on a video hearing on Google Meet. He's 2,000 miles away, and he fucking made her lose her shit. Oh my God, she's gonna fucking spurg out in court. I'd hire him. Guys, you just watched a fucking Alex Spiro just walked in there and just like took out his knife and went like he's like shh. It's like John Wick. He's just shoved it right in and walked away. That was brilliant work. I'd hire her. She's like, that's what these people do. Yes, that's what we do as defense attorneys, Carrie. You know the hustle. You're part of that game. It's all in the game, yo. They got the shotguns. We got the briefcases. That's how this works. You know, that's how this works. That's how it's supposed to be. You know that. I get it. You're mad. You got hustled by a hustler. But he caught you with your pants down. I mean, what? You're going to bitch and cry about this? Yeah, this is what $1,000 an hour. Look, chat. This is $1,000 an hour. Now, can I make the same arguments he is? Probably. Would I be as good as he is? Probably not. He's definitely a better attorney, better speaker than I am. But this is what $1,000 an hour gets you. Fucking guy who comes in online and fucking murders a person through a camera. And Bella, you said this earlier. It's not that he hired slimy people. He hired fucking diligent, good attorneys. And they're fucking putting the screws to her. They're making her do her job to a T. And they found a leak and they exploited it. So, yeah. Yeah, she fucking hurting, chat. And she intentionally mispronounces his name. I don't think she does. I think she's just whatever. You know, she's like, them fancy New York lawyers. You fancy. What is that? What do they say in Blazing Saddles? You look like, he's like, they look like a couple of Kansas City faggots. It's like, woo-wee. You know, like, I am seeing dollar bills if this goes to trial. Oh my God. Yes, she has and will bitch and cry. Yes. Get him on the show. There is no way that fucking guy will ever come on here. I will, you know what, Stabby? Because he's in the middle of dealing with this. If he gets it dismissed, I'll interview him. I'll send out an interview request to his office. He's going to be like, what? He's like, I'm billing $1,000 an hour. Fuck you. And I wouldn't blame him for saying that. He's like, dude, I'm making fucking money. Banging supermodels and like doing coke. Or whatever else he does. Oh, note to self. Never give them New York City lawyers an inch. 10K, here's the deal. Note to self. Never underestimate your competition. Doesn't matter if it's a New York City lawyer, if it's some guy from shit-kicking Ohio. You should presume every attorney you're going up against is going to be very, very formidable. And then when it finds out that's not the case, fine, you're fine. But she thought, oh, they're just going to be big city attorneys. Like, I guess she didn't thought, like, they know how to litigate, or she didn't realize this guy could fucking fight. I mean, she thought this was going to be easy, and this guy came suited up. So, here we go.
I never said that they couldn't testify about what people told them. I didn't want Hancock testifying about what people told her if it wasn't going to be responsive to the question.
Then you let Hancock
That
say
is
it and you
clear.
figure it out.
I'm not going to have Hancock talk about gun safety on movie sets if all she knows is the wrong way to do it. Hearsay is admissible in grand jury. All of that was absolutely appropriate. Mr. Rice's testimony was perfectly appropriate. It was based on hearsay. This court knows very well that hearsay always comes in before the grand jury. But if I'm talking to a detective and I know that her answer is going to be based on unreliable hearsay, and that's what it was unreliable hearsay, then I'm going to stop it because I want the grand jury to get the most accurate responses to their questions. You know, Mr. Spiro wants to say to this court this morning that I'm just kind of making this up as I go along. That I had no intention of ever presenting anyone over video. I can give you the names of the DAs in the second that I spoke to.
But you didn't. You came up with an idea, but you never implemented it. You didn't have those people on standby where they were told to be ready. It wasn't like they were sitting at home, sitting there like, oh, I might get called. You didn't prepare any of it. You had a plan, but you never enacted step one. So you're talking about all the stuff you were gonna do. You didn't fucking do any of it.
Prior to taking this case to grand jury, to ensure that this was a practice that was normally done. And why am I speaking to DAs in the second rather than DAs in the first? Because DAs in the second deal with more complicated cases. They see more alert letters. So that's the reason that I was reaching out to them. I'm not going to sit here and be called a liar. I absolutely did.
You might not be a liar, but you sound fucking incompetent. Jesus.
I did everything that I have told the court that I did today. He's right. I didn't reach out to Mr. Hall's attorney, and I didn't tell the court today that I did. So let's be clear. Mr. Spiro is intentionally trying to misrepresent and mislead this court right now. Thank you.
All right, thank you, counsel, for your presentations. I am going to issue my ruling by order next week. I'll put it in writing, okay?
Oh, no.
Thank you, Your Honor.
You may look for that. Thank you very much.
Well,
We are in recess.
I'm assuming that's one of the court report. That's the court reporter, RPR. Certified. Yeah, she's the reporter to New Mexico court. Now we're done. Oh!
When was the last time I took a road trip? How many?
I wasn't joking, Chad. I said total fucking prosecutor death. Total prosecutor death. Wow. Wow. Oh my God. I'm glad we watched that tonight. Woo! God, Kiri got her fucking ass handed to her. That was not good. I mean, God damn. Oh. When will it come out? Sometime next week. God, she got fucking riggedy wrecked. Total state death, chat. Oh. Yes, Toto Vader, you're right. Rich people can afford really good lawyers. Alex Spiro represented Musk in a trial. Uh-huh. Yep. Oh, so, this draws some serious coin. Yes, it is. I think the witnesses not being in the hallway will clinch this. I think so too. And it was the thing, if they were set to go on video, like she could say, I had them all ready to go. They were sitting there on, I had them sitting in a chat room, all ready to go. I had them in the back lobby of a StreamYard, ready to go, one at a time. Yeah. And W. McMaster, you're right. The Trump case doesn't count 100%. Yep. No. I agree with you. This is awfully cringe by the defense, considering the double standards currently in the courts against Trump. And it's not really cringe. Dude, you fucking go after what you go after. It's cringe that this is a symptom of prosecutors fucking with things, and Trump getting fucked with by prosecutors is a good example. Brittany says, it goes to trial. Will it be televised? Yes. Judge Sommer will allow cameras in. McMaster said, I dislike that I'm on her side now. Well, curious to know if that changed at all. Yes. She self-stunned herself. Carrie Morrissey did, yes. And yes, Alex lawyers have tried to make her life a legal hellscape. Oh, I guarantee it. I guarantee you this is like fucking horrible for her to deal with at times. But hey, you declared war on Alec Baldwin. He fires back. Like, that's how this goes. Zoom meetings mean no pants. Well, I mean, you can wear shorts. Like, I've worn like shirt, tie, and jacket upper and like shorts underneath or pajama pants. That happens. McMaster says, keep in mind the entire time this guy is defending a guy that shot and killed someone. Sure. Remember, it's all in the game. It's all in the game, yo. To quote the great warrior poet Omar Little. They play their games. He plays his. Carrie plays her games. Spiros plays his. And if Spiros could play a better game than Carrie, the quarterback and the linebacker do their dance. Crowding a shelf of larger law books. I actually picked up a nice set of books, so I'm actually good on that. Thank you, though. Oh. And Patty says, can a prosecutor get charged for mishandling a case? No, bumbling it up and all that. No. Now, like if they were to like tamper with evidence or things like that or intimidate witnesses, that could be an issue. But no, just like, oh, you fucked it up and it got dismissed. Like, no, not like that. Janet Morgan says for $10, we live in a world where both Trump and a Trump impersonator, and that's a good point. Going back to McMaster's point, Alec Baldwin plays the role of Trump, so he's getting fucked too. Are both getting screwed by a zealous prosecution. Yes, they are. Kind of looking like it. But thank you, Janet. Oh, chat. Let's see here. Was she appointed? Yes, she was appointed. Like she was appointed, but they could certainly they would have talked to her beforehand. Like, would you agree to prosecute this? And then they appointed her as special prosecutor. So. Jim says she gave two different incongruous answers. She didn't reach out to the lawyer because he was not responsive. Yeah. Well, like she had probably tried to talk to him before and he never got back to him. But still, just like that one, what about the rest of them? Like, he would have been here if I asked him. Like, well, why didn't you ask him? Because I didn't think, like, I would have worried about that when it happened. It's like, no. Why didn't you have everybody fucking ready? You could have ready. If she had like one or two witnesses, like everybody but Dave Hall, like, yeah, Joel Souza was here. They were all ready to appear by video. I had them all ready to go. She'd probably be fine, but this is bad. This is bad. Sean putting in his application for the appeal and Baldwin about now. Yeah, I mean, if this is all appellate, guys, this is all on the record for an appeal. So if this goes to trial and Baldwin gets convicted, this is coming out on appeal. What about the lawyer's comment about retrying the grand jury? I mean, honestly, if she's forced to dismiss it because the indictment was defective, I'd argue that's because it's procedural, it's prosecutorial misconduct. I'd argue that it should be dismissed completely. Like, Alec's team must be very confident. And this is where I'd love to ask Spiros, Attorney Spiros and Attorney Nikas. Are they that confident they'll get a no bill if the grand jury is presented with what they want? Because that could be. Because, remember, we talked about this. Spiros he's got a pedigree as a prosecutor. Or does he think no matter what, they'll win at trial? I mean, why wouldn't you just go for the fucking throat and say dismiss with prejudice? I mean, maybe I guess he's concerned that for Alec Baldwin, then the cloud always hangs over his head that he was never found not guilty. And actually, I'm thinking about it. That's probably what he'd say. If we do that, then he's never found not guilty. We want a jury to no bill him because a no bill would be a vindication, and a not guilty is a vindication. J-Rock says, no, they know it's going to trial. I don't know. I mean, I think they're prepared. And God, these guys are going to fucking... This is going to be what Bowles should have been able to do. I'd be asking for the fucking dismissal, like, with prejudice or, yeah. But I understand. Alec Baldwin needs the vindication to redeem his public image as best he can. No way that the judge dismisses the case. I mean, this is not... Here's what I'd say ultimately. I'll make my statement now. It is 1:34 a.m. on May 18th, 2024. What's going to happen? She's not going to dismiss it, but it's going to be really close. It's going to be really close. Like, she's going to be like breathing on the idea of dismissal. Like she's going to be that close. She's going to be really close to dismissing it, but she won't. And then Alec, like, here's the deal though. Given the way his attorneys are fighting, oh my God, I think they're going to fucking demolish her at trial. That's what I think is going to happen. Joe Loyce has been in the public eye. He shot a lady. Sure. But he's not going to win the entire public back. A bunch of the public hated him already. But that way he could say in a vindicated way, I was found not guilty, or the jury no-billed me. Yeah. Yes. Just like Jurassic Park. No, we can't run. No, we can't make it. She's close. Yeah, I mean, that's the thing. She's no Bowles. They ain't no Bowles. They're going to be better. I mean, that's it. I do a better job in Bowles. I mean, fuck, a first-year law student probably do better in Bowles. So here's what's going to happen. J-Rock, I think you're right. As far as copium's concerned, we're still going to have the trial, chat. Thank God. She's going to be very close to doing it. She won't. Baldwin's going to go to trial. I mean, God, if his attorneys are coming this hard, I think they might win. I think they're going to be phenomenal at trial. They're going to crack Carrie so bad that he might win. But it's going to go to trial. Slimmest amounts, slimmest of margins. So there's my prediction. Go play the clips of Super Chatter asked for, which nobody asked for a clip here. Hold on. Oh, Phil Foss clip. Yes. Sorry. All right. What did guys, Phil Fosse's been making all these funny clips of people covering the trial here. There's some good ones. Let's see. Where are they? Oh no. Oh God. Oh no, I made my own. All right. Oh, God. Okay, here we go, chat. Jesus. All right, here we go. Some days I really have constructed my own personal hell. All right, here we go. So there's other ones here. So he did one about trial bingo for the so there's a couple of them, apparently. So here we go. I guess there's two. LawTube Sean, he's a real lawyer, I guess. Uh-oh. I'm curious to see what this one's about. Okay, here we go.
Screaming and shaking my arm, and I attempted to Google how long does it take to die in the cold.
How long did it take for him to die? Hold on a second. Clyde! Come here, Bob. Come here, Bubba Bear. Click, 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 click. Come on, buddy. Up, hey. Up here. Come on. Come on. Hey. Wait. Wait. Come here. Dude, come on. Come here. Clyde. Come here. Clyde, up. Come here. Go far away. Come here. Come on, Clyde. Jesus Christ, Phil. Clyde. Hey. Come here. All right, fine. You're not getting it. I did 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 it. Boom. Holy Jesus. Thanks, Phil. Thank you. Hold on here. Oh my God. So here we go. Here's the other one.
Arguing that he has to show bad faith is incorrect on other than the sufficiency of the evidence. So I don't think that was properly addressed by you. Now I'm going to ask you.
Let me translate. Uh-oh. Uh-oh. That's not good, chat.
Let's go to the information about the lack of advisement about the target. The target, you saying that reading the target alert letter went above and beyond what you were required to do. And you gave some information about at the very end, you even reminded them of the boxes. And I'm just wondering why you wouldn't have reminded them of the witnesses as well at that time.
Ooh, uh-oh. Uh-oh.
Well, the reason that I wouldn't have reminded them of the witnesses is because
uh-oh,
they had the target's alert letter in their hands the entire time. I know for a fact that they reviewed it, and you can see that from the transcript.
How can a grand juror ask questions from a transcript?
I agree with you, Your Honor, and this was one of the things that was discussed during the hearing with Judge Ellington.
Chat, you need to hear that again.
Bukaki?
Wait, why did that? Hold on. What?
Arguing that he has to show bad faith.
Oh, chat, you need to hear that again.
Bukaki?
Oh my God. Oh. Yes, I got felted by a dog. Thank you. Oh. So. Half-Fire said that made me snort and laugh. Yes. So are you gonna buy an Uberti as a tax write-off or a Uberti Cimarron special model? Or I'm not gonna buy the Colt ones. Colt's quality sucks, man. I would get an Uberti. I get what Alec Baldwin got. Alec Baldwin got a Pieta. He got a Pieta Cattleman with an I forget the exact setup, but I'm gonna get that. If he ends up going to trial, he's thinking about getting one, but we'll see what happens. Then we'll use it as we'll use it as a demonstration aid. But we'll see here. So, yeah, that was not good today for the prosecution. Yes, thank you, Darcy. And she's like, I told you. Lol. Thank you. Thank you for this. Darcy again for $20. Thank you, Darcy. I done told you, lol. You need to dress up for a cowboy stream. Do I look like I shoot sass? Do I look like I do? Do I look like I do the cowboy shooting? No. That stuff is cringe, man. Where's Lainey the larger and superior dog? Dude, if I ever get the chance to hold Lainey, I'll probably cry. Because that dog has been through so much. She is so scarred and scared. Like, you've seen it when 2.0's brought me in and I've held her. It's like she is so tense and freaked out. Never, like, no. No. So, yeah. You could fan it real nice. Yeah, I could sit there and just... But, yeah. I'm too fat to wear a Western holster. What, they find a belt big enough. That's not the issue. Think about it, though. If I'm so fat, my bandolier would have 1,000,000 bullets on it. So I could shoot forever. I have 1,000,000 reloads. Boom, and I just reload. I keep reloading because I have so much real estate on my belts and my bandoliers. See, that's why you skinny bitches, you can only carry so much. Don't get no gun. Don't get no Wild West gunfight with me. I can outshoot you. Oh. So, all right, guys, that is it for tonight. And yeah. We are gonna just keep our eyes peeled, see what happens. Like I said, I think probably ultimately this is gonna turn out in the state's favor, but it's probably gonna be scathing. And then I'm sure there's gonna be more motions from the defense if that happens. And actually, I wonder if we're still gonna go to trial in July. So, anyways, that is it for tonight, guys. Tomorrow, like I said, I don't know what the plans are for tomorrow. During the day, I'm gonna be outside spending time with 2.0. In the evening, I'm not sure. We might do something. We'll see. Saturday night, Sunday morning, we're gonna do F1. We got a race. And yeah, kind of go from there. Keep play it by ear this weekend. In the meantime, guys, enjoy your weekend. Take care, and remember, even though just because Alec Baldwin admitted it doesn't mean he's guilty. Good night, you guys.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when